But I'm waiting here till 1:15. In case it is not taken, but can I take up at 2 p.m. I'll take.
2 p.m. it will not be possible because there are civil
Then
matters.
appointed me any time today in the first hour.
I think it will not be possible. Let's see how it goes.
My lord, I am for the, I am mentioning on to the FMAT, the copy has been served.
Which one?
Which FMAT 22, that is, they mention a MBA,
Ah.
FMAT, the insurance has been preferred the appeal, but they haven't paid the statutory deposit. And in spite of the order, there is the order, they have been not deposited the amount.
Ah.
So, my lord, kindly the inclusion.
What order to pass? They have paid for stay.
No, stay. Also, they have been paid for stay.
Let them come up with their application.
Lordship, because of the, they have been didn't pay the compensation amount, deposit the amount. Lordship, kindly inclusion in this. Kindly, Lordship, I have served the notice.
Huh?
Lordship, I have served the notice. Lordship.
Who is for the insurance company?
Missing. Missing is there.
Sit down. Nearly.
My lord,
Which you may have to mention. Criminal revisional method.
Ah.
Connection with relaxation of anticipatory bail condition. Bail was passed by the learned district judge Jalpaiguri. Now we are able to withdraw this application.
Need.
my lord, may I be permitted to mention one contested application from civil motion? My lord, it's a first matter appearing as today's list as item number 32.
32.
Yes, my lord.
Yes.
No, it's a transfer application. My lord, can you text it up today?
See.
Lordship, may I permit to mention one criminal divisional matter for extension of interim order, Lordship. Lordship, to another matter, FMAT MB, Lordship, for section 5 application we have.
You are for the insurance company.
Lordship, I am for the insurance company. I served notice upon the
You have served.
Lordship.
Lordship,
I
I mentioned on the which has granted stay of the investigation. I am the de facto complaint, Lordship. That has been pending
Yes,
for
sir.
a long time, Lordship.
Next sir.
I'm praying for leave from the honorable court. File civil revisional application without the original certified
No.
copy. As because
No. Let's call the list.
Well, that is.
Your Honor, due to the prolonged.
Okay.
Please, madam. But there is an intriguing question of law involved. In item number 1, but whether a prosecution complaint under NDPS Act can be filed only on the basis of coactive statement. As your lordship is aware of about the position of law after Tufan Singh a coactive statement or an accused statement even so recorded under 67 is a non-sequitur act. So therefore, there is no evidentiary value of that statement. On the basis of that, whether a complaint can be filed, because as your lordship is aware of, here complaint is equivalent to a police report under section 173(2), which has to meet the test of section 170. There has to be sufficient evidence or reasonable ground in terms of 170. Already, the very basis of the complaint is the coactive statement. With deepest respect, how can that satisfaction of reasonable ground or sufficient evidence be made? If I may request your lordship to come to the complaint so file. Page 26 P1, sorry, P3 is the complaint. The petitioner before your lordship is a Dubai-based businessman. He was arraigned as accused number 3, page 26.
Page 26.
My lord has got it. But kindly see, my lord, what is remarkable, it's mentioned against him, accused number 3 not yet arrested. Then, my lord, kindly comes to page 27, paragraph 2. My lord, on 28th May, I'm sorry.
No,
On 28th May, my lord, a source information was received. My lord, this is very crucial, if I may place. It is submitted that on 28th May 2024, a secret information was received by such and such that regarding, my lord, then your lordship will see the name Rahul Rahman, my lord, accused number 1, aged about such and such, is trafficking codeine-based syrup in Coach Bihar, West Bengal. He is having his go down at such and such, such and such. So the secret information was accused number 1. Then my lord, there is a search operation conducted. Then my lord, the seizure your lordship will have at page 29. The entire, my lord, whatever the codeine mixture was seized. From 29 to page 36, my lord, they have encapsulated.
Page 29.
My lord, 29. Please just the mention, my lord. It's mentioned what are the things which were seized from accused number 1. Then, my lord, my complicity will come. If I may request your lordship to come to, my lord, paragraph 15 at page 38. My lord,
You are Zakir Hussain.
no, my lord, Zakir Hussain is the person from whose premises, my lord, it was recovered. I am, my lord, Asif.
Asif.
Right. Para, my lord, if I may place this, Rahul Rahman is in his voluntary statement confessed that he is the owner of such and such bottle of cough syrup.
No. Which paragraph are you reading?
Oh, I'm sorry, my lord, para 15 at page 38.
Yes.
That Rahul Rahman, my lord, if I may,
Yes.
I'm obliged. Rahul Rahman in his voluntary statement confessed that he is the owner of 5,000 bottle of fensidyl cough syrup out of the total 1,649 bottle seized from Zakir Hussain, which had purchased from Asif Hashar of Mirak. He further acknowledged that the procuring fensidyl cough syrup from Asif, he used to store such and such, such and such. So, my lord, only allegation against me that it was purchased from me. Against that to 5,000 against any bill. So there is no transaction. Now, my lord, if I may request your lordship to come to, my lord, page 42, para 29. My lord, para 29 says that's from the facts mentioned above.
Yes.
It is clear that despite repeated summons, Asif has not joined the investigation. As per the statement of Rahul Rahman, it was Asif who has supplying him fensidyl syrup without bill. So there is no documentary evidence. Then my lord's pleasure will be to come to, my lord, page 58, my lord. It's a lengthy complaint, my lord. The other parts, presumption, narration of facts, which do not touch me, my lord. So I am not troubling your lordship. Page 58, rather, my lord, 59 to be more specific. Your lordship will see the charge sheet was, I mean, the complaint was prepared. What I was named as item number 3. Page 59, I am accused number 3. Again, your lordship will see not yet arrested. And my lord, the prayer your lordship will have at the next page, issuance of process. To take cognizance, my lord, para 88. In view of the above mentioned facts, complainant humbly prays before this honor that your honor will take cognizance and will be pleased to admit the complaint against the following persons. Then your lordship will again see I was not arrested. And I have annexed the seizure list, my lord, for your lordship's consideration, which my lord will have at page 67. The seizure list will show, my lord, it was seized from the house of accused number 2 on a statement under section 20, allegedly under section 27 of accused number 1. So I am not into the picture.
Yes.
Now, my lord, apropos this, my submission before your lordship, my lord, the complaint so filed against me is a non-starter because there is no prosecutable evidence to file a complaint. But the similar issue is pending before the principal bench also. If I may place 2 orders before your lordship, not in connection with this proceeding, my lord, absolutely in a different proceeding, but the issue is similar, my lord, subject to correction by your lordship, my lord. If I may place these 2 orders, my lord. If I may place this order, the petitioner such and such was implicated in connection with the case number on the basis of the statement of co-accused recorded under 67. It is submitted on behalf of the petitioner that no contraband article was recovered from the petitioner. Apart from the statement of the co-accused, the prosecution relied on the all detailed report between the principal accused and Anusura Begum on the date of occurrence, it is submitted by the learned advocate for the petition that the call detailed report may raise a suspicion against the petitioner, but only on the basis of such suspicion, accused cannot be booked in an offence under the NDPS Act. Therefore, the petitioner has prayed for quashment of the criminal proceeding. Let this be admitted, madam. The notice was directed to be served and no coercive action was. Second page, your lordship will have the last 2 lines, no coercive action, which was also, madam, subsequently followed by another bench, madam, where, madam, the Tufan Singh judgment was also, madam, quoted in the second order, madam, which I have just handed over to your lordship, and the similar protection was given. But since it is at the motion stage, madam, I want to keep it very simple. That, madam, there is no prosecutable evidence against me. My anticipatory bail was rejected by the learned trial judge, madam. Before the division bench, I filed a petition, madam, which I have withdrawn because there were some, material wrong statements mentioned, madam. So there is no adjudication of anticipatory bail. But here issue is, madam, if the prosecution complaint has no character in the eye of law, where the petitioner, madam, whether there should have been any further proceeding. Madam, at this stage, madam, since this is a fresh matter, I am praying before your lordship, madam, for notice and no coercive action.
My lord, if I am confident, my lord. My lord, NCB seeks to enter appearance. And if
I
my
have a copy.
learned friend gives a copy, we'll hear out the matter.
Can you give me
A date be conveniently given to the convenience of the court, and my learned friend, he's coming from outside. And one go, we'll finish it instead of keeping it pending.
Absolutely, my learned senior friend is here, so we'll serve in course of the day. I will be requesting for an interim order till the next date of hearing.
My lord, he is not arrested, and he is beyond the clutches of law, he's in Dubai.
My lord, no question, my anticipated stood rejected and the prosecution.
No, my lord, his anti-bail did not stood rejected, he withdrew it. I was
The
there.
learned trial court.
So I'll put,
But had it been by the division
No,
bench, I could
my
have
lord,
covered your lordship.
my lord,
That would have been a case.
we
of
will
court.
demonstrate 5 notices were issued upon this petitioner. He did not respond. So and whether there is a tangible evidence or a cognizable evidence, that is a matter of trial, madam. Let the investigation go.
No, it's complaint file, there's no investigation going on.
Need not,
It's a charge sheet.
need not,
Which is why, madam, there's no scope for investigation.
need not.
This is the
It's a
completion of.
completion, madam. Or then it's a charge sheet. It's in the form of a complaint.
No, my lord, it is not charge sheet. Charge sheet is to be filed.
No. How can that be NCB file charge sheet? Madam, we deepest this, but how can NCB file charge sheet? They can only file complaint, madam, at the completion of investigation.
Fine, my lord. Whatever there is a record,
If there is charge sheet, then cannot be any prayer for issuance of summons.
I'm obliged, madam.
my lord, whatever, I do not have the case diary with me. I will get it
Perfect.
because there is another bail application, the same case pending before the honorable division bench, which has been fixed on
No, not
Thursday.
by me.
No,
By an
not by
accused.
you.
From whom, madam, it was seized.
So, my lord, notice may be given to us.
And madam, I'm requesting for an interim order, madam.
No, let it be heard on Thursday.
Yeah, absolutely. Any day that's convenient to your lordship.
This criminal revision has been filed challenging the proceedings arising out of NCB crime number 03/NCB/SLG এগুলো capital /2021 dated 30th May 2024 under section 8 within bracket C read with section 21C/25/29 of the Narcotics, Drugs and Psychotropic Substances Act 1985 within bracket hereinafter referred to as NDPS Act, pending before the Learned Additional District and Session Judge, First Court, NDPS Kuch Bihar. For quashing of the proceedings. Mr. Ayan Bhattacharya, learned senior advocate, appearing for the petitioner, submits that the learned trial court only on the basis of statement of the co-accused has taken cognizance of the offence against the petitioner. Recorded under section 67 of the NDPS Act. relying on the decision of, you have the judgment
But that,
of Tufan Singh. He submits that.
what are the first one? I prepared a compilation for your lordship. What are the first one will be.
Okay. He submits that the statement of the co-accused has no evidentiary value. No evidentiary value. And as such, the proceedings against the petitioner is out and out not sustainable in the eye of law. In light of his aforesaid submissions, the Tufan Singh versus State of Tamil Nadu, reported in AIR 2020, AIR 2020 SC 5592. বাকিগুলো আছে, we have taken news. Only one I am referring to. He also places reliance on the orders passed in a similar circumstances by the coordinate bench of this honorable court in CRR 884 of 2023 and CRR 5122 of 2021. Any of this application has been disposed of?
No, madam, both are pending.
Both of them.
Both are pending.
He seeks for an interim order so that no coercive action is taken against the petitioner. Mr. Mojumdar, learned advocate, DS, submits that the copy of the application be served upon the Union of India or NCP, which is the party?
NCB.
NCP.
We have made union, madam.
Union of India, representing NCB to Union of India. So, peruse the complaint. It is found that seizure has been made from accused number 1 from the house of accused number 2.
Most obliged, madam.
In the complaint, it has been mentioned that the complicity of the present petitioner has diverged from the statement of a co-accused, namely Rahul Rahman, accused number 1. Bearing in mind the aforesaid, this court finds that an arguable case has been made out. Accordingly, the instant revision is admitted. Petitioner is directed to serve notice upon the opposite parties to registered speed post with acknowledgement due and file affidavit of service on the returnable date. The investigating authority is restrained from taking any coercive step against the petitioner till for a period of 6 weeks, 4 weeks, 6 weeks, 4 weeks. Eight of start next
10th of February.
10th of February comes 4 weeks or 6 weeks.
Most of.
6 weeks. Let it be 6 weeks or until further orders, whichever is earlier. Parties shall be at liberty to pay for modification.
Obliged.
Release this matter before the next available circuit bench to serve the copy.
Madam. Obliged.
Can you just take out one, Mr. Huda? Can you just take out Tufan Singh and give a
But
photocopy?
actually, I was only one thing has been confirmed by the Honorable Justice Court in Khaliluddin. And contrary.
Okay, let them come. You get the copy and only Tufan Singh will give them. Next.
Number 2.
Lordship, I am for the petition in this case, 10 of rule. But a very peculiar situation arises in the petition. But the petitioner and purchased the four-wheeler on loan. Certainly, the four-wheeler was deposited by the bank on the ground of non-payment of EMI. On 10th of October 2023, the vehicle was deposited and documents will show that it was sold out on 10/10/23 itself. Surprisingly, the bank went on deducting the account of the petitioner till March 2024. Because it was a police complaint made. police
So after
was not-
seizure, the bank has sold it out.
Yes.
Okay.
No matter, there was a, on this scenario, a writ petition was filed before the honorable court. And the honorable court was pleased enough to pass an order that the jurisdictional magistrate will dispose of the matter after hearing all the objections and grievances of the petitioner had. Petitioner went before the trial judge and filed an application to verify the signatures of the petitioner admittedly and those appearing in the transfer documents. Apparently, those were not similar. Now, this petition was kept pending. Petitioner attended the court. Suppressing everything, the opposite party files another writ petition or maybe CRR without impeding the petitioner and obtains an order from the honorable court that the case pending before the jurisdictional magistrate shall be disposed of the next day fixed. On the next day, the jurisdictional magistrate, by bowing down before the mandate of the honorable court, disposed of the application by releasing the vehicle, and the application of the petitioner for signature and verification is still pending. Now, my simple prayer is, my lord, the order be recalled and we given a chance to participate in the CRR, the court will decide what should be done. A writ court had passed an order that the petitioner's objection should be heard. I have annexed that order. My lord, we find the order at P2 at page 12, my lord. My lord, the page, internal page 2 of the order in view of the, has you also got? Last paragraph of page 2, my lord, page 13. May I read? In view of the grievances canvassed by the present petitioner who has installed the criminal case, being Bhaktinagar police case number so and so was registered for investigation and the London jurisdictional magistrate being in testing of the matter, I direct that the release of the vehicle in favor of any party would be subject to audience provided to the petitioner and objection raised by her. In case the London magistrate will concerning the application's opinion that for transfer of the vehicle, the signature which was produced before the registering authority was questionable or allegedly forged, it would be the discretion of the London magistrate to allow the petitioner to prefer appropriate application, and the London magistrate will apply his mind for taking further course of action in accordance with law. There was a clear direction in the real court that if there is a doubt about the signature and if the petitioner files an application to that effect, you will take that in consideration, apply your mind and decide it accordance with law. Now, while disposing of the CRR, the Honorable Court directed dispose it of. On 18th of January, the case was disposed of while the application of the petitioner that was pending in the record is still pending. No, my lord, at
Court
page-
records that the honorable court on 8th January 2024.
Yes, my lord, we were not a party to that.
Where is that order?
My lord, page 17.
Who is this person? Satyam Prasad Gupta?
Is the OP before the trial. And the respondent is the writ petition. A very tricky question comes up that a direction from the constitutional court can be overridden by the statutory court. Revisional court is a statutory court. A writ court is a constitutional court. Same honorable judge, my lord. Honorable judge. And 18th, my lord, the petitioner was before the court. I personally went down for the hearing, but the magistrate was due to some departmental or administrative work was not found to seat. In the evening, the order was passed. And the record will reflect that the petitioner on many occasions with their advocate was present before the jurisdictional magistrate, but the hearing did not take place because with due respect, I submit my learned friend for the other side was not available. The two orders are colliding. And the petitioner very intelligently did not draw to the attention of the revisional court that the writ court has already passed such an order, which was said that you have to verify the signature. And it is needless to say before your lordship that writ court gets the predominance.
In the writ petition, the action of the bank was challenged.
Both action of the bank and also we were dissatisfied with the police.
Inaction of
Mainly it was against the bank. And my lord, I should, in my duty, I would fail in my duty if I don't draw up your lordship attention to another fact. A civil suit with on this is pending before the concerned court. From the civil suit, civil court will take into account whether the account deduction was proper, whether the reserve reposition was proper or not. But why this hide and seek, my lord?
this order passed in the writ petition was communicated to the court.
Yes, my lord. The petitioner brought out an application to get her signature verified. We had annexed that application also in the application, my lord. My lord will find it page 15.
But this application has not been disclosed.
No, my lord.
This was prior to filing of the writ petition.
No, this petition, this page, at page 15, my lord, came after the writ court passed the order that.
Okay.
Then this was filed. This was not heard, neither objection filed, pending in the record. The opposite party or the accused before the CJM approached the revisional court and obtained this order by not making another part.
This criminal revision has been filed by the petitioner.
No.
For
Kindly excuse my presence. I am actually going to my junior second. I am very sorry. To
Yes.
Thank you.
बोलो
This petition has been filed by the General Court.
challenging order dated 18 January 2025 passed by learned Chief Judicial Magistrate Jalpaiguri. The fact of the case is that the petitioner took a loan from Ind Bank, INDUSIND, to purchase a four-wheeler sedan. After obtaining such financial assistance, the petitioner purchased the car and was using the same. Stop. However, the said vehicle was repossessed by the bank. The petitioner lodged a criminal complaint, which was registered as Bhaktinagar Police Station case number 905 of 2023, dated 10th October 2023, under section 379(34) of the IPC. The petitioner also filed a writ petition being WPA 1338 of 2024 before this court, and in this said writ petition, video order dated 11 July 2024, direction was issued to release the vehicle in favor of any party subject to audience. It was also directed that if the learned magistrate is of the opinion that for transfer of the vehicle, the signature which was produced before the registering authority was questionable or allegedly forged, it would be the discretion of magistrate to allow the petitioner to prefer appropriate application. Pursuant thereto, the petitioner filed an application for verification of signature. It is contended that without deciding such application, the learned magistrate, video order dated 18 July 2025, has released the vehicle in favor of opposite party number number 2. Mr. Sudipto Mojumdar, Kumar Mojumdar, learned senior advocate, appearing for the petitioner, submits that the vehicle in question was illegally repossessed by the bank and was subsequently transferred. However, the signatures appearing in the transfer form is not of the petitioner. In the writ petition, such fact was considered, and the learned magistrate was directed to take into consideration any such application of the petitioner questioning the signatures appearing in the transfer form. The learned magistrate, while releasing the vehicle, did not decide the application filed by the petitioner for verification of the signatures. In Form 29, 30 and 25. He seeks for stay of further proceedings in GR case number 5303 of 2023. Further proceedings for further proceedings, number 10 authors. Upon perusal of the records, it is found that the petitioner has contended in the written complaint that he availed of a loan for purchase of the vehicle in question, which was repossessed by the bank. The facts further show that the said vehicle in question was transferred to another person. There is dispute with regard to the signatures in the transfer form. In paragraph, in WPA 1338 of 2024, this honorable court, this court passed the following in view থেকে report করে দেবে। Para. Pursuant to such direction, the petitioner filed an application for verification of the signature in form 25, 29, and 30. in CRR 7 of 2025, following direction was passed. Needless thing. It is found that the learned chief judicial magistrate, while releasing the vehicle, has not decided the application for verification of signature filed by the petitioner. Accordingly, this court finds that an arguable case has been made out on behalf of the petitioner. Criminal revision. Hence, the criminal revision is admitted. Issue notice upon the opposite parties. There shall be stay of. Accordingly, there shall be stay of all further proceedings in GR case number 5303 of 2023, arising out of Bhoktinagar PS case number 905 প্রথম থেকে নিয়ে নেবেন এটা ওখান থেকে কপি করে আমি বলতে হবে স্টেড স্টে বললাম না proceedings for a period of 6 weeks or until further order, whichever is earlier. And parties shall be at liberty if this matter before the next ordinance of law. Yes. আর পিটিশনকে দিয়ে দাও, নোটিশ দিয়ে দেবো to the office of
This is one of its kind. Before your lordship opens the brief, this is a quatrain petition. The petitioner before your lordship was the erstwhile range officer attached to Raidak range. What happened, madam? There was a bidding for plantation in 2022. Now, one Arif Hossain, he was a successful bidder. The work order was issued by the DFO. He completed the work. Completion certificate was issued by the petitioner. Then petitioner got transferred from Raidak to Alipur, South 24 Parganas at Sundarban. The new incumbent he stopped the payment. Since there was no disbursal that successful bidder Arif Hossain filed a writ petition before this honorable. And why I have opened my mouth saying this is one of its kind, I tell you lordship now. When the writ petition was taken up by this honorable court, it was found that the completion certificate issued by me was illegible, which was annexed as such. That was commented on by the honorable judge that this is illegible. You file a fresh one, and the department also directed to produce a copy of it. That was produced. Then it was placed before another honorable judge. The honorable judge held that what was mentioned in the completion certificate, and there was a right of hearing given to the successful bidder. In that right of hearing, an order was passed. Their finding in the order was contrary to the completion certificate. Nothing else, Then the matter was posted for hearing. In the meantime, the present range officer filed the FIR against the successful bidder and the erstwhile range officer, which is the petitioner before your lordship only, saying that he followed the YouTube video of live streaming of court proceeding, wherefrom he got to know that there are directions by this honorable court to file an FIR. But there is nothing of that sort. On that, there was an FIR filed. I just take your lordship to before I take your lordship to the FIR.
Yes, stated in the live streaming such direction was issued.
Nothing, no live streaming, I have all the order sheets. No order sheet, even the honorable judge who was in session of the matter, he expressed surprise. He granted leave to me that you file your a copy will be handed over to you. You file supplementary affidavit.
No, it is pending.
It's pending, and this court is in session of that. And what I have learned from your lordship, what is recorded in the order is the ultimate outcome, But kindly see page 2061, before I take your lordship to the FIR, only very few pages, I will be placing before your lordship. Prior to that, there are earlier writ petition. The first writ petition order your lordship will have at page 206. My lord has got it. If I may place, my lord, para 3 will be relevant, my lord. The petitioner claims an outstanding amount arising out of the tender work allegedly successfully completed by the petitioner. However, the work completion certificate, then you also will see page 55 to the writ petition totally illegible, and this court cannot read a single line out of it. Then, my lord, learned State Council also submits that they are also not in a position to read the same. Then, my lord, in view of the above writ, the writ petition shall appear before the next available circuit bench under the heading motion, subject to legible copy of completion certificate being filed by way of a supplementary affidavit to be affirmed and filed by the petitioner upon copy therefore furnished to such and such State Council by Justice Roy. Then, my lord, sees the document 208. Because this document, my lord, I have shown, my lord, page 206. Kindly comes to, my lord, 2051. This is part of supplementary. Just the previous page, my lord. Pursuant to that order, my lord, 205 document has seen the light of that. This is a supplementary affidavit file. Then, my lord, sees 208. This is a work completion certificate. It was signed by me. I never disowned the certificate, but that I have signed it. I have not signed it, sorry. Then, my lord, sees page 209 by Justice Joyce and Gupta, my lord. If I may place, my lord.
Yes.
Affidavit of service and supplementary affidavit filed on behalf of the petitioners are taken on record. Learned counsel appealing on behalf of the petitioner submits that there is a stark discrepancy between the recent order alleging non-completion of work and completion certificate that was issued by the respondent authorities. Learned counsel for the state prays for time to obtain instruction. Let a report be filed. Then, my lord, I will request your lordship to come to the FIR, which your lordship will have, my lord, at page 213. Then I will show, my lord, the order passed post there. Page 213, my lord. I'm sorry, my lord, it's not 213, I'm sorry, 215. I'm sorry.
Yes.
If I may place, my lord. I, Partho Sarothi Pramanik, WBFS, Divisional Forest Officer, Jalpaiguri, such and such division lost this FIR, informing that the writ petition was filed within writ petition number 481 of 2024. I came across a work completion certificate with a memo number such and such, and after verifying the same, I found that there was no such document in the office record. Further, the document which was issued by the then officer, then my name mentioned, Kabir Hossain, son of not known, presently posted at the office of the Divisional Forest Officer, 24 Pargana South, phone number such and such, could not be issued by him as per law. My lord, can you mark this? This is a false statement. That such document was a fabricated and false document which has been intentionally issued by Sheikh Kabir Hossain in connivance with such and such. First of all, my lord, if the document was issued by me, there is no question of forgery because I have issued the document. Then, my lord, if I may continue, next paragraph. After detailed scrutinization of both the documents, it seems that the documents are not bearing the same contents and seem to be fabricated. Hence, it is clear that the demand of the contractor is fully ill-motivated and the said document is false and fabricated. The matter has been informed to the higher officials to our department. Then, my lord, again, as per the directive of the Honorable High Court at Calcutta, Jalpaiguri Circuit Bench, reference YouTube video link such and such, and after verbal discussion with the higher officials, such and such, this FIR was filed. Now, after this was filed, let's see the order of this Honorable Court by Justice.
Akib is the proprietor of trade in
Who was the petitioner, madam, successful bidder?
for claiming for the outstanding dues.
I'm mobilized, madam. He is not before your lordship now. Now, kindly comes to page 210, madam.
Yeah.
Learned advocate appealing for the state submits already a case has been registered with Kotwali police station in respect of the documents relied on for the claim which is the subject matter of the writ petition. A copy of the FIR be handed over to the learned advocate for the petition, which is generally not done by this Honorable Court. The petitioners who deal with the acquisition in the FIR, if required, would file a supplementary affidavit. But this Honorable Court is in active session of the matter. This is overreaching the jurisdiction of this court. And there is a false statement made, my lord, why I have said so. Kindly comes to the regulation, my lord, which your lordship will have at page, my lord, 18. This was issued by, my lord, the DFO, page 18. completion certificate, my lord, can only be issued by the range officer. My lord has got page 18. Well, kindly comes to page 21, clause 37, 31. These are the two clauses. Page 21. No, I'm so sorry, my lord. Page 18 it starts, my lord. 1A. Because that was the work order, my lord. With that work order, my lord, the terms and conditions, everything was mentioned. Page 21, para 30, 37, 38, if I will take.
Page 18,
Page 18 it starts, my lord. Then kindly comes to page 21, my lord.
21.
My lord. Then, my lord, serial number 37, if I may place, and 38. Payment shall only be made to the contractor after the range officer concerned certifies to ensuring the quality of the work and implement of the work as per estimates and plans subject to overriding power of the undersigned in this regard. Then Mala, the next one. The mode of payment for successful completion of the work will be made by NFT, RTGS, non-banking issued by the tender inviting authority. Payment on submission of the completion report by the range officer. It can only be issued by me. I don't dispute that. This honorable court is in active session of the matter. Now, we deepest respect now since the charges in the FIR, my lord. On the basis of that, my lord, page formal part your lordship will have at page 218, my lord. Admittedly, no money was disbursed, which is why, my lord, 409/511. And the other charges 468, my lord, there cannot be 468. Any forgery in order to cheat, because I am the author of the document and I don't dispute the document. 471 is also, my lord, equally misplaced, and 120B. But since I'm a public servant, my lord, I'm requesting for no coercive action only. I will join the investigation, my lord, and I will participate.
But then there is a direction in the writ petition that the state would proceed in accordance with law in respect of FIR register.
Right, my lord, that they will do, my lord, which is why, my lord, I cannot ask for any stay. Your lordship is absolutely right. I cannot request for a stay, my lord. The investigation will go on and your lordship will record my statement or on condition that I will participate. Your lordship is absolutely right. Which is why, my lord, I'm not praying for stay. And this court was in session of the matter, and your lordship understands, my lord, in that writ petition, this honorable court cannot cause the FIR, my lord, which is why I had to file a fresh one. And with deepest respect, I have all the order sheets, my lord, most of the order sheets are. And I have
But
all
it's
the
not
order
the-
sheets in the writ petition, my lord.
I think this submission should be made before the writ court because there is a direction.
But only
Whether he will be-
difficulty, but I do understand, but only difficulty if your lordship kindly appreciate, if your lordship sees this order, my lord. But the order, I think, of Justice Ghosh,
Yes.
if I may place this, sees para 2, a copy of the FIR be handed over to the learned advocate appealing for the petitioner. The petitioners who deal with the acquisition in the FIR and if required would file a supplementary affidavit. The state would proceed in
This is
accordance
this.
with law in respect of the FIR. So that they will do. Only no coercive action
No.
so far I am concerned.
No. Then again, this will be intervention into the.
But only the difficulty is that kindly appreciate, I am not a petitioner, part in
I
the
have
writ
understood,
petition,
but this
I'm not
this particular
party.
observation goes against you. It will continue with this in accordance with law.
Kindly
Passing
appreciate.
any line, no.
May I just take 2 minutes time of your lordship, then I will leave it to your lordship's discretion. But I don't request for any interim order which will impugn the investigation for the time being. Now, in the writ petition where that order was passed,
No, this should be approved before the report for modification of it.
party, your lordship is right. It can be filed, it should have been by the writ petitioner there, who was the successful bidder. I am not a party in the writ petition, my lord. Then we deepest respect, how can I be I can approach for the report, in the writ petition, so far the writ petition is concerned, I am a persona non grata. It's only, so far the writ petitioner is concerned, who is the successful bidder.
Now, since the FIR has come into existence
Right,
and the
right.
petitioner has been given liberty to deal with that in supplementary affidavit,
Deep problems, but I am not the
But-
petitioner, my lord. Your
Yes,
lordship is
yes.
right.
you have the, you can always approach the court
But
because this is
my
acting
point.
against you.
At the most, then your lordship will see that this 482 will be heard along with the writ petition, my lord. Because otherwise, kindly appreciate, since I am not a party in the writ petition, then my rights will be impugned, my lord. Infringed, in fact, my lord. And since kindly appreciate, my lord, if I am not a party in the writ petition, will depends respect, my lord. It was liberty, everything was granted to the writ petitioner, my lord. Even the liberty which was generally not granted by your lordships, my lord. My lord, handing over a copy of the FIR, hardly that sort of direction is passed, my lord. Then, my lord, can you direct this writ, I mean, forward it to be placed along with the writ, my lord, so that I can take, because otherwise, my lord, I will be arrested any point of time and I'll publish and I lose my job, my lord. And you will also have seen the YouTube video was referred to, my lord. This is something unheard of, my lord. So very fulcrum of the proceeding is bad, my lord.
This criminal revision is fine. For quashing of proceedings being, this is what is PTN?
PTN.
Yes, in the prayer portion, page 12.
But there is a corresponding PTN, my lord, which you
This is GR, not GR number.
But there is no GR number given as of now. There is a PTN number given as of now.
Okay. PTN 3 of 2025 arising out of Jalpaiguri Kotwali Police Station case number 0021 of 2025 dated 9 January 2025 under section 409/511/468/471/120B of the Indian Penal Code.
And may be placed along with the repetition.
Let the state come
Perfect.
thereafter direction.
Perfect, as your lordship.
But this you have the liberty to be added and implemented in the writ petition.
Only difficult one is there that
This contention can be raised before the writ court. You can file an application that you be implemented as a writ petitioner and then proceed according to law. Once a direction is issued.
False from your lordship, that only what is troubling me, my lord, since in that subject matter of the writ petition is something different, and wherein my lord, I am not a party, whether I
Now,
can.
since if the court takes into consideration the contents in the written complaint, that goes against you. As of now.
Right, which is why I am before
So
you.
that if that is decided without you being heard or you don't get yourself implemented, since you have the knowledge, you have annexed the order.
Right, my lord. So, my lord, what I request your lordship will issue notice so far this is concerned. And let me take, my lord, I mean, let the state come. And in the meantime, I will file an implement application there, my lord. Only what is.
After you get yourself implemented in the writ petition, this becomes honest. To infractions.
Then I will withdraw, my lord. Till such time, at least I will have some protection, because if I am arrested, you will also understand, my lord. Is settling the score, the new person safety. And he is saying, I am the author of the document, I never dispute the document. Everything is before the writ court, my
Then
lord.
let the state come. Looking, কি বললেন? Mr. Oyon Bhattacharjee, learned advocate for the petitioner, submits that the petitioner was the erstwhile. Just give the rank, erstwhile.
My range officer.
Erstwhile range officer of
Rydak range, my lord.
Raighat,
RYDA. Rydak, my lord. Rydak range.
Raidak catchment range. During his tenure, work order was issued in favor of one Akib Hussain, proprietor of Trade Ind and Trade Ind, and completion certificate was also issued in favor of Akib Hussain. Since there was outstanding dues, Trade Ind filed a writ petition claiming such outstanding dues. being WPA 481 of 2024. As the certificate of completion was found to be illegible, there was direction issued for production of the fresh copy of the illegible copy of the certificate. During the pendency of the writ petition, and when the matter relating to the outstanding dues of the party in favor of whom the completion certificate was issued was seen before the court, the present range officer lodged a written complaint alleging of forging of signature in the certificate of completion. He admits that the signature in the certificate of completion is of the petitioner. So the question of forgery does not arise at all. He also informs the court that there is no such payment made to the Akib Hussain, in whose favor completion certificate has been issued. The sections quoted in the FIR, namely 409, 511, 468, 471, 120B of the IPC, has no manner of application so far as the facts and circumstances of the case is concerned. He seeks for an interim order of stay or of an order not to take any coercive action.
Most of it.
Admittedly, the trade-in has filed a writ petition being WPA 481 of 2024, claiming outstanding amount arising out of a tender work successfully completed by the petitioner. During the pendency of the writ petition, the present range officer has lodged an FIR alleging of forgery and misappropriation. It is found that by order dated 10th January 2025, this court in WPA 481 of 2024 has directed that the state would proceed in accordance with law in respect of FIR so registered.
May I just assist your lordship kindly? But I just repeat your lordship will kindly recollect one thing. But in every bail and anticipatory bail order, the general directions are passed that you will participate in trial, you will remain every day present. But can that be a fetter on me to filing an in order to file a 482 matter? It means that if there is a proceeding that will go on. But only matter I have an independent right to file a separate petition.
But that is not the similar fact as we are here. The proceedings and direction has been given.
17, these are the
State would proceed in accordance with law and respect FIR so registered. In view of the above, the prayer for stay of the proceedings or to pass or not to take any coercive measures is not considered. Issue the criminal revision is admitted, issue notice upon the state.
most of it.
It is found that the matter is to be heard in presence of only state is the
Number
party.
opposite party number 2 is there. The de facto.
The opposite parties are required to be heard. Admit, issue notice upon. After such petition is directed to serve notice in the office of the additional public prosecutor, circuit bench of Calcutta High Court at Jalpaiguri, and also upon opposite party number 2 through registered speed post with acknowledgement due and file affidavit of service on the return orders. Is this matter before the next available circuit bench?
Well, may it appear under the same heading, but for that motion, I can pray for interim order before that.
Let it appear under the heading contested, then mention and then get it done. Let it appear before the next available circuit bench.
More important. Your Lordship recorded that your Lordship has not considered my interim prayer, but may it be at this stage so that I can renew my prayer. Otherwise, the honorable judge will say that no, it was already refused in fact.
No,
At this stage.
no,
Very.
no.
I will not.
Get them.
Most of it.
Yes. Thank you, sir.
Well, may I take your Lordship?
Yes.
Okay, number 4.
This is my application for stay of warrant on 12th of November 2024. Warrant of arrest was issued against the petitioner's notice. The petitioner number 1 is 70 years old and he's completely paralyzed. Lordship, he cannot move. And the other petitioners, their labor lordship. So
What is this case?
Charge sheet has been submitted. Limited the petitioner will surrender.
Who won't surrender?
Short stay maybe not.
Well-
Stay maybe.
When was the charge sheet filed?
Charge sheet was filed in the year 2017.
17. And you are absconding for last 6 years. This criminal revisional application.
On 13 consecutive days.
What section?
Where is the copy of the charge sheet?
What section?
439. Here message there. Have you this give the copy? Give the charge sheet copy to me.
Number 1 is 70 years old and he is completely paralyzed.
Yes. Mr. Okay, this criminal revision has been filed. Challenging for stay of operation of order number 12, order dated 12th November 2024, passed by learned judicial magistrate, Chief Judicial Magistrate Jalpaiguri in connection with GR case number 3876 of 2015, arising out of Banarhat Police Station case number 267 of 2015, dated 11th September 2015 under section 341, 323, 326, 34 of the Indian Penal Code, in short IPC. And charge sheet number 146 of 2017, dated 30th June 2017. Mr. Anirban Banerjee, learned advocate, appearing for the petitioner, submits that. Who is the aged person who cannot move? 1, 70 years. Submits that the petition number 1 is an aged person and hence the petitioners could not appear,
Rest of the tea garden laborers.
and rest of the petitioners are tea garden laborers, for which reason they could not appear before the court. He seeks for stay of, for which reason?
Completely
Huh?
paralyzed, lordship, he cannot move.
Aged and paralyzed. You know, and warrant of arrest has been issued against them. He seeks for stay of execution such warrant of arrest, and also undertakes that in the meantime the petitioners will surrender before the Court of Learned Chief Judicial Magistrate, Jalpaiguri. At the outset, it is found that there is no medical documents annexed to the petition. So far as, which one?
সেটাই তো বলছি, so far as other effects is concerned.
Hypertension.
May I find for you, lordship?
No. কি বললাম?
There is no legal document annexed to the petition, so far as
I put inside a right vessel. মোবাইল আছে? কি বললাম? Have annexed medical documents. Note up again. Annexed medical documents of petition number 1. However, all those are five-year or more old documents. No recent medical documents have been placed before the court. Is found that the charge sheet has been submitted in the year 2017.
Sir, it's in medical survey, lordship.
17. Admittedly, the petitioners failed to appear on more than more than 13 consecutive dates. Such being the position, this court finds no merit in the application. Accordingly, the criminal revision is dismissed. 17. Yes.
Dismiss though.
Next. Next.
Your Lordship, item number 5.
Item number 5 and 6.
Mr. Pradeepan Ganguly will be appearing in this matter.
Hmm.
However, he is available. only-
I'm for the respondent.
Opposite party.
Opposite.
Number
I'm for the two.
two.
They have filed one application, I find, as served on my advocate on record, that they have filed one for extension of interim order.
And 8.
Can 8.
7
That-
has been disposed of.
No, 7 they have filed for addition of party. They want to add. No, 7 is for extension of interim order, and 8. I'm very sorry, Millard. I should have indicated the first, and I apologize, Millard. 8 CRN can 8 is for addition of party. CRAN 7 is for extension of interim order. And Millard, they want to use a supplementary affidavit because I am the complainant. So they have come for questioning. Now they want to use the supplementary affidavit which they have served to put in record the charge sheet. But these are the 3 things that they have done.
What is 5 and 6?
But 5 and 6 has not been served on me. I do not know, my lord, what 5 and 6 is. I've been served with CRAN 7. 5 and 6 is my application. Oh, my lord, that may be my applications which I had filed in their quashing applications. Let Samuel, let Emmanuel Ekka. Ekka is, my lord, my client, my lord. We are opposing actually their application for quashing. In the meanwhile, what has happened, my lord, that there is some talk of settlement between the two are going on. But I am on instructions to submit to your lordship that to smoothen that settlement and let peace come, my lord. I am on instructions on that. So, my lord,
Circuit logic in between we will
whatever.
Settle the issue. What are the sections?
But this is originally a complaint under the SCST Prevention of Atrocities Act. Although not compoundable in that sense, your lordship is correct. But for petroleum company officers who had come on my client's spot and place of business and abused and all that, we filed a complaint that led to writ petitions and all that. So after that, they want to make peace. Why should
I'm
I?
not recording that your submissions that talk of settlement is going on.
My lord.
But on your submissions, I'm placing this matter before. In the meantime, if it is withdrawn, then fine. Both the learned advocates for the respective parties. Which is the extension of interim order?
CRAN 8.
Mr. Ganguly is there in the version. Ms. Supriya Singh, learned advocate for the petitioner, it a CRAN 8 order called. 6 for extension of the interim order. Accordingly, let the interim order be extended for a period of 6 weeks or until further orders. CRR Act heading করবে। No, no. 5 number extension. Extension application হচ্ছে 7. ঠিক আছে? এবার একটা হেডিং করুন CRR 157 of 2024. Both the learned advocates submits for fixing the matter before the next available circuit bench. In view of such submissions, let the matter appeal.
Deeply obliged. Deeply obliged.
5-6 হয়ে গেল contested. None appears on behalf of the petitioner. এটা কোনো রিপোর্ট দিয়েছে? অর্ডারটা কি কমিউনিকেটেড দিয়েছে? অর্ডারটা কি রেজিস্ট্রারের কাছে গেছে? আছে। Non appears on behalf of the state. On 21st January 2025, it was submitted on behalf of the opposite party state that nationality verification of the petitioner is under process. And it was also informed that a report has been submitted before the learned registrar, Calcutta High Court, Circuit Bench and Jalpaiguri. And learned registrar, Calcutta High Court, Circuit Bench at Jalpaiguri was directed to place report. Here is the report of the registrar dated 22nd January 2025. It is found that since passing of the order on 12th August 2024, no report has been received from the Special Inspector General of Correctional Service, West Bengal. Regarding completion of nationality verification. Accordingly, the registrar is registrar, Circuit Bench of Calcutta High Court and Jalpaiguri is directed to call for a report from the Special Inspector General of Correctional Service, West Bengal, regarding completion of nationality verification of the petitioner. আচ্ছা, ওপরে লিখেছে petition is not represented. Let such a report be placed before the next available circuit bench. Next.
Lordship, I am for this state. The last occasion. Report to be filed from the Inspector in charge Siliguri Women PS. So this is the report. Present status. The 7325 has been fixed for year of WA. WA has been issued against this Vishal Kumar.
What is this order? Bail cancellation.
Lordship. Bail has been cancelled, against that they have preferred, and WA has been issued. He is absconding, Lordship.
Bail was granted by the Sessions Court.
Lordship.
Bail was granted by the Sessions Court.
By the Sessions Court, Lordship. Lordship, it is in annexure P2, page 17, Lordship.
This was a regular bail or anticipatory bail?
Lordship, the copy they have given to me is very illegible, Lordship. 438 probably. Lordship, the first line, page 17, annexure P2. What is Lordship? It's 438 probably. Or 439, because the copy is very illegible, Lordship. Our copy. 25,000 each. 438 too, Lordship. And Lordship, the last line will comply with the provisions of 438(2). Subsequently, not complied, and the court cancel the bail.
This.
Anticipatory bail. Lordship,
None appears
no,
on
sorry.
behalf of the আগে হেডিংটা করে দিই this criminal revision has been
এটা আমাকে দেখাচ্ছে বলে
ordered 18th October 2020 passed by learned Sessions Judge Darjeeling in connection with criminal miscase number 113 of 2022. 1 3 of 20 number तो भूल गए 2022 I think. What is the date of the order?
Lordship, the bail order, Lordship.
No, cancellation order.
Cancellation order is, Lordship, 18/10/2022. The certified copy they have filed.
And the CRR number is
Lordship, JO code number such and such, case number 113 of 2019.
19. Okay.
Miss case
Number
number.
19 হবে। It will miss case number 113 of 2019. Bracket A in connection with criminal miss case number 56 of 2020.
সুতমার মজুমদার কি সেই? সুতমার মজুমদার।
ওটাকে in connection টা কেটে দিন। না,
Lordship, the lawyer for the petitioner was our DSG now.
in connection with Siliguri Women Police Station case number 18 of 2022, dated 11th February 2022, within bracket GR case number 808 of 2022 for commission of offence punishable under section 376, 417, 420, 506 of the Indian Penal Code, in short IPC. None appears on behalf of the petitioner on repeated call. On 21st January 2025, also the petitioner was not represented. Accordingly, the matter is taken up for consideration and disposal on merit. Para, in compliance to the previous order dated 21st January 2025, the state opposite party files status report, which is taken on record. The fact in nutshell is that the petitioner was granted anticipatory bail by the learned sessions judge, Jalpaiguri. No, Darjeeling, no?
Darjeeling,
Sessions in
Lordship.
Darjeeling. Subsequent thereto, an application for cancellation of anticipatory bail under section 439(2) of the CRPC was filed by the complainant. Upon considering the materials on record and hearing the party, the learned sessions judge Darjeeling cancel the bail of the petitioner in criminal miss case number 113 of 2019. VD order dated 18th October 2022. Being aggrieved by such order, the petitioner has filed the present revision. Mr. Sourav Ganguly, learned advocate for state opposite party. Submits that the learned sessions judge has considered the reports of the police authority, which revealed of threatening and pressurizing the de facto complainant. And in consideration of the same, the prayer for anticipatory bail has been cancelled. Hence, the order impugned does not call for interference. It is the impugned judgment and order. Judgment order. It is found from the order of the learned sessions judge that it has considered the reports dated 22nd July 2022 and 27 July 2022, wherefrom it revealed that the de facto complainant has received threatenings from various persons who were close to the accused petitioner, and were pressurizing the de facto complainant from not to disclose the truth before the court or the investigating officer. Considering the said reports, the learned sessions judge has cancelled the anticipatory bail of the petition.
Which subsequently warrant has been issued.
As per the report submitted by the state, warrant of arrest has been issued against the petitioner. Considering the aforesaid, this court finds that there is no merit in the application. It is dismissed.
Deeply appreciated.
Next,
বড় হবে
My lord, item number 9, I beg to appear on behalf of the petitioner. My lord, if your lordship kindly
Lord,
directs your
item
court
number
officer-
9, I will be appearing for the respondent number 2.
My lord,
For
the
the
video
private
has
respondent
been,
number 2, I have instructions to appear and oppose.
my lord, the video has been disabled. If your lordship kindly directs the court officer to switch on the video,
দেখো কিছু হয়েছে
the video. My lord, I have been led by Mr. Shekhar Kumar Basu in this matter, my lord, learned senior counsel. My lord, still the video is off.
ওরকে ফোন করে বলে দাও আপনার সাথে করে
Yes, it has come.
Yes, it's come. May I please, your lordship? If your lordship kindly, my lord, there are two applications which are still pending till date. That is CRAN 4 and CRAN 2. My lord, CRAN 4 pertains to an extension of interim order. And so for CRAN 2 is concerned, my lord, this relates to a vacating application of the order passed by my lord Justice Vivek Chaudhary way back in 26th of April 2023, while granting the order of stay with a specific observation why this matter has to be stayed. If your lordship kindly have a look into page 20 of my extension application in CRAN 4, and it's a detailed order. Well, there are two petitioners who happens to be the father-in-law and the mother-in-law, the septuagenarian father-in-law and mother-in-law, who on consecutive occasions has been discharged by the investigating agencies. If your lordship kindly have a look into the order first. Thereafter, I will advance my argument.
Order dated
26th of April 2023, page number 20 of CRAN 4. আপনি চলে আসুন। And it's a detailed order.
ওরা লিখেছে, ওরা অ্যাসাইন করেছে।
এই স্যার ঘুরে গেছে কেন?
Yes.
Yes. Mr. Basu has already joined in the link.
Yes.
Okay. Anyway, Manoj has gone through the order in detail. Yes. Now, Manoj, what has happened? Manoj, unmute call. Manoj, what has happened, Manoj? After a long 13 years of marriage, Manoj, the lady has committed suicide. Now, if your lordship kindly, Manoj has, if your lordship kindly takes up my main application once. Manoj, the charge sheet, the first charge sheet, the second charge sheet has to be assessed, Manoj. Manoj, if your lordship kindly takes up the first charge sheet, at page 46. And I'm just asking for an extension of interim order for the time being, because this matter has to be heard in length. And my lord, moreover, we are going to file and reply of the vacating application filed by my learned friend, Mr. Bishas. My lord, Mrs. Das, my junior, is present today before your lordship. She is going to file the affidavit in opposition of the vacating. My lord, page 46 is the first charge sheet. If your lordship kindly turns to page, the relevant portion is at page 48, the last paragraph.
Who is for opposite party number 2?
My lord,
But
Mr.
I am
Bishas.
appearing. But I am appearing for the opposite party number 2.
Okay.
Well, though initial interim order was asked, but at this point of time, my lord, I have instructions to oppose because I have also filed a vacating application. My lord, that has to be heard out too.
One of the vacating application with deepest respect to my learned senior friend, but it's a defective application. The principal order is of 26th of April 2023. My learned friend didn't challenge that order. He has challenged the order dated. Now, this is very surprising. Extension application. 23rd of August 2023.
Page 46.
Yes, 46 is the charge sheet. Relevant portion is at page 48. And may I please read the last paragraph? Hence, I submit charge sheet in this case against the accused Barun Agarwal, who is the husband, such and such, White Kashyang, police station charge sheet number 81/19 dated such and such, against 498A306, against Barun Agarwal, son of Deoraj Agarwal, he is petition number 1, the father-in-law, to stand his trial in open court of law with a provision to submit supplementary charge sheet. In the case, if any further development or any progress in the investigation. I also pray that the remaining 2 accused persons, namely the petitioner number 1, namely Deoraj Agarwal, and petitioner number 2, Sabitri Agarwal, in lack of conclusive evidence, keeping in view that the supplementary charge sheet will be submitted in case of any further development. My lord, this charge sheet has been taken into consideration by the learned magistrate. Thereafter, being aggrieved and dissatisfied with, my lord, the private opposite party number 2 has prayed for a Naraji application. That was subsequently allowed. Thereafter, again, the first supplementary charge sheet was filed. If your lordship kindly turns to page 58. No, this is absolutely shocking.
Page?
How the investigating, page 58. Page 58. It starts from page 58. Thereafter, my lord will find the relevant portion is at page 62. Again, the last paragraph. On the basis of material already available in the case diary, I am submitting supplementary charge sheet. White supplementary charge sheet dated such and such against Deoraj Agarwal and Sabitri Agarwal to effect their trial in the Honorable Court of Law. Again, they have been discharged. My lord, I stand correct, my lord. If your lordship kindly comes to page 51 once. I'm reading a wrong charge sheet. Page 51.
51.
51. The relevant portion is at page 55.
51.
51 is the supplementary charge sheet. The relevant observation, the operative part is at page 55. The last paragraph.
Yes.
My lord,
Hence, I consulted the merits of the...
Just a moment, my lord, just a moment. I have been called in courtroom number 29. I'm just joining. My learned junior will assist your lordships. I'm joining back, my lord. And Mr. Uday Shankar Sarkar is also present there physically to assist your lordships. I'm just coming in a moment, my lord. I have been called by courtroom number 29. And I'll just come and rejoin with your lordships on virtual mode. But Mr. Uday Shankar Sarkar is present there. But he will assist your lordship, so will my junior. My lord. I'm just coming, my lord.
Yes. Sure.
Yes. My lord, if your lordship kindly go through the last paragraph of page 55, the first supplementary charge sheet. Hence, I consulted the merits of the case with my superiors by submitting the memo of evidence in the case, and who, after hearing the facts and thorough perusal of the CDs, they were pleased to order me to submit supplementary charge sheet in the case under section 498-306 IPC against Barun Agarwal, the husband. Hence, I do hereby submit charge sheet in the case White Kashyang PS supplementary charge sheet number 113 of 2021 under 498-306 against FIR named accused person Barun Agarwal to face his trial. Hence, my lord will find the last two lines of the first supplementary charge sheet is, may kindly Savitri Agarwal and Devraj Agarwal may kindly be discharged from the case as there is no evidence to suggest their involvement in the incident.
Yes.
Now, before taking your lordship, before beseeching your lordship, the second supplementary charge sheet, which has been done in a most illegal manner, complete against the it's a complete violation of law. Will kindly have a look into on what basis in both the first charge sheet and the first supplementary charge sheet, the names of the petitioners being the parents-in-law has been discharged. If your lordship kindly go through the statements of 74, 75 and 76 of my application. None of the independent witness, none of the relatives, nobody has taken our name. There is nothing against the parents-in-law.
Page 75.
74, 75 and 76. We have annexed each and every 207 papers with our applications, with the main application.
Page 75.
74, 75 and 76.
74.
Yes.
Who is this person? 70.
74.
Bina.
Yes, Vinanka Goenka.
Ah.
The relative of the private opposite party number 2.
Okay. Yes. What is she states?
She has categorically stated, she is also the next door neighbor of the victim and the petitioners. She has categorically stated in the 161 statement, she has raised fingers against the character of the husband. The husband used to assault her. He is a person of questionable character, but not a single observation has been made by her against the parents-in-law.
Yes.
Yes. And 75 and 76 is just the same. It's just a carved copy and paste of this statement of 74. Now, my lord, if your lordship comes to the second supplementary charge sheet. This is shocking. Page 58, the relevant portion is at page 62.
Yes. You just,
yes.
Please indicate.
Yes, ma'am.
The first supplementary charge, second supplementary charge sheet. Probably this is the third one.
Absolutely. Deeply obliged.
In between this period, what was the development in the investigation and what were the statements recorded by the...
My lord, I'm exactly coming to that point. Now, with the same sets of documents, my lord, this last supplementary charge sheet was filed. There was no further statements, no further materials whatsoever collected by the investigating agency. This is the most surprising aspect of this case. My lord.
So page 55 is the second supplementary charge sheet submitted on 28th August 2021.
Yes.
And this is 15 September 2022.
Yes, my lord. Page 58.
So as per you, in this period, there was no further investigation?
Nothing. Considering the same sets of documents, same sets of 161 statements, on the same sets of materials collected during the course of the investigation, one of the last charge sheet has been submitted.
Okay.
This is last but not the least. My lord is well aware of the fact that the Honorable Apex Court in its case in Sohan Lal, it's a landmark judgment. My lord, where the Honorable Supreme Court has held that are subsequent cognizance taken by a learned magistrate merely on submission of second supplementary charge sheet is deemed illegal. The action of the magistrate of taking cognizance is per se an offense and not an offender. That's what Sonlal says. So, my lord, what I humbly pray today, my lord, kindly extend the interim order for the time being. My lord,
Why we are hearing the matter?
no, my lord, because we are going to, my lord, submit some compilation of judgments as well, my lord.
Mr. Basu
That's
is
right. Yes, Mr. Basu is there. Sir, আপনাকে শুনতে চাইছি।
Lord, he has made his submission correctly, but we have filed our reply. We have filed our reply to the vacating application. So, but this vacating application may be treated as the affidavit in opposition of the complainant. And Lordship can fix a date for hearing of the matter, final hearing of the matter.
Then it goes to the next circuit. It cannot be taken up in this circuit.
That is.
Next circuit.
Which one is the application for extension?
Grant 4.
Grant 4.
Affidavit in opposition. Five. Against the bracketing application being grant 2 of 2023 filed by opposite party number 2 is taken on record. Mr. Shekhar Kumar Basu, learned senior advocate, appearing on behalf of the petitioner for extension of the interim order granted earlier, which is the date on granted on 23rd, 26th April 2023. Also submits for fixing the matter
আমরা দেখিয়েছি পেজ
or hearing before the next available circuit bench. Seeks for extension of the interim order বলেছে তো?
দেখি দেখুন পরপর পেজ 60
Mr. Joydeep Biswas, learned advocate, opposes such prayer for extension of interim order,
Even state also, Lordship.
as well as the state opposite party opposes such prayer for extension of the interim order, since a vacating of the interim order has already been filed by the opposite party number 2. Considering the submissions advanced at the bar, the interim order granted earlier on 23rd April, 26th April 2023 is extended for a period of 4 weeks. Place the matter before the next available circuit bench or until
The order will be 23rd of August 2023.
26th.
The 26th April is the principal order, the first order. The last interim order was on 23rd of August 2020.
Our principal order is 26th April.
26th of April.
Yes.
my lord, your lordship is extending till কতদিন
For a period
Your
of
lordship,
4 weeks. Next circuit.
My lord, may I just humbly pray for one indulgence, my lord. My lord, if your lordship is extending the interim order, lordship will kindly fix up a date for hearing so that we both can go and conclude the hearing at last.
Sir, it is for the convenience of the next judge who comes up in the circuit. I just have directed to place the matter before the next available circuit bench. You mention and get a convenient date from the judge who will be deciding over the circuit bench.
Grateful to you.
Deeply extremely.
Petitioner. This petition has been addressed by the petitioner. But what he
Just a minute, Mr. Das. Document Shimani Babu. ওই আগেরটা না একটু ক্র্যানটা দেখে নেবেন, ক্র্যানটা ডিসপোজ অফ করে দেবেন। আগে যেটা এন্ট্রি মডেল এক্সটেনশন ক্র্যান 4 বলছিল, ক্র্যান 4 এপিডিবি সার্ভিসটা নিয়ে ওটা ক্র্যানটা ডিসপোজ অফ করে, ঠিক আছে? ক্র্যান 4 ইজ ইউর অ্যাপ্লিকেশন ফর এক্সটেনশন।
What copy can be given to me? You have the
Yes,
copy?
yes, Mr. Das.
This petition has been advanced by the petitioner for washing of the proceeding before the learned trial court being sessions case number 35 2024, which originates from the clear case number 538023 and the mark PS case number 832/2023 15/10/23 pending before the session judge at Malbajar. Now, my submission before your lordship, before going into the issue, I like to place before your lordship the FIR, which has been designated as page 12. You.
Service upon the complainant, complainant is represented.
A complainant is not being represented, but the service was copy was served through the police station
What is that?
as per direction of the honorable court. And affidavit of service is already filed before your lordship.
You have sent the affidavit, you sent the notice through speed post.
To the police station to for service. And it's a case of 376.
কিছু বললাম অঙ্কিতা অঙ্কিতা দেখে যাও তো
অঙ্কিতা একটু আসো তো এদিকে।
ওরা কি এটা করে নেবে নিজে থেকে
তাড়াতাড়ি দেখ, আমার পরের আইটেম আমার ইয়ে হচ্ছে না কেন দেখছো? পরের আইটেম আমার নেমে গেছে তো, 10 চলছিল তো, ওই তো কোট রয়েছে তো 10 আইটেম। মানে পরের আইটেমটা আমার, বুঝেছিস? হম 10 কন্টিনিউ করছিল, দেখো তো কত কন্টিনিউ করছিল।
এখন অফ করে দিলাম ভিডিওটা অফ করে দিলাম
হ্যালো, না স্যার বেশ ভালো আছে। বারো ধরে নিয়েছে আমার ম্যাটার, কিন্তু ইজ নট ফাংশনিং। আমার জুনিয়র রয়েছে, ওকে বললাম অ্যাডজমেন্ট নাও।
ঠিকই তো আছে।
যে করলো ওরা মানে আমি আর
নাম্বার করে
শোনা যাচ্ছে? এই তো বলছি।
না না ওখান থেকে কোনো প্রবলেম হচ্ছে ওদের একটা টেকনিক্যাল প্রবলেম হচ্ছে
কি হবে গড নোজ।
অনলাইনে প্রবলেম হচ্ছে জুনিয়রকে বললাম যে বলতে যে অনলাইন
আরে ও তো রয়েছে, 12 ধরে নিয়েছে, তো ওকে বললাম তুমি অ্যাডজমেন্ট নাও, দিস ইজ দ্য প্রবলেম। কি করছে গড নোজ। তো বলো কোড নেমে গেছে।
ওই হচ্ছেই তো না, ওরা তো নিচ্ছেই না, ওরা বন্ধ করেছে।
কারণ
কারণটা কি?
তুই এটা পাঠিয়েছিলি?
সব পাঠিয়েছিলাম, না হলে তো মিস ইয়ে করে না, এলাও করে না।
হয়ে গেল মামলা, কি যে করবে কোর্ট আমি জানি না। মামলা হয়ে গেল কি যে এটা খুব সিরিয়াস ম্যাটার। ও তো মামলা ধরে নিয়েছে, আমার জুনিয়র রয়েছে, যদিও টাইম দেবে কিনা বলা যাচ্ছে না। না
that point of time. She was staying with me at my residence and she was continuing with this. Because, my lord, we have a daughter, my lord, we could not take any steps against her. But now then she has voluntarily removed herself from her matrimonial home. She has stated to be staying somewhere else. And this is the crux, my lord. Here, my lord, some allegations have come. Now, if your lordship kindly comes to page 55, there are certain dates given, my lord. Now, I'll just place it, if your lordship may I place it, my lord.
Yes.
Yes. অভিযোগ কারণে such and such now থানা রাজগঞ্জ জেলা জলপাইগুড়ি. Here again she is saying that she is in Rajganj. Second one, my lord, she was in Banarhat. First, Rajganj. Now says, my lord, I'll say এত তারিখে সামাজিক বিবাহ, এত তারিখে তাদের এক কন্যা সন্তান হয়, no dispute with this. হওয়ার কারণে কানের মেশিন. Now, my lord, kindly sees. The only constant is the differently abled daughter. Now I can, my lord, we have stated, my lord, that we have no quarrel with her with regard to our child being a differently abled child. In fact, there is no quarrel from our part. Dates have been added, my lord. I will not trouble your lordship with the entire thing.
Not her child, your child.
Our child.
Yes.
Our child. My lord, I will not trouble your lordship with the entire. My lord will, because the factum of the entire case is that we have been constantly harassed by the de facto complainant on one pretext or the other.
So sum and substance of the complaint are almost the same.
Sum and substance are same, names have been added, some facts have been added.
Okay. This is what your submission is?
These are my submissions. I am, my lord, praying for quashing of complaint.
My lord, I am for the opposite party, my lord, the wife. My lord, my learned friend has demonstrated the harassment he has been subjected to by my client. But my lord, the other side of the story, my lord, is yet to come before your lordship. My lord, the first case, my lord, in the year 2020 was filed by my client against her husband, alleging, my lord, torture. Now, my lord, in the year 2009, in the year 2009, my lord, they got married. And subsequently, my lord, a girl child, my lord, had taken birth from the wedlock. My lord, unfortunately, the girl child is a differently able child. And my lord, that was one of the reasons, my lord, for inflicting torture upon my client. My lord, having no alternative, my lord, the complaint under 498A with the, my lord, the allegations, my lord, have been leveled against the petitioner. My lord, after the first complaint was lodged, my lord, there was a salishi between the family members. My lord, my client was, my lord, has been persuaded to come back to her matrimonial home, and my lord, not to affect her matrimonial life, she went back to her husband. She started staying. My lord, during that period, my lord, from 2020 to 2022, my lord, she conceived several times. And my lord, just because the first child was a differently able child, my lord, she was forcefully, my lord, subjected to undergo abortion for several times. And my lord, last time, my lord, she suffered a miscarriage due to the torture of, my lord, the in-laws as well as the husband. And my lord, that led to lodgement of the second FIR, my lord, alleging miscarriage by my client. My lord, the sum and substance are not, my lord, similar. My lord, first complaint is torture, second is torture. The first complaint is the background that has to be stated in the FIR. But the sum and substance was that she had suffered a miscarriage due to the act of her husband as well as the in-laws. So there was a, my lord, joint, I would say, my lord, a joint action against my client by all of the family members, the petitioners. Now, my lord, during that time, when the lady was in hospital for several months in different course of intervals, my lord, she is a marriage officer, and some of her documents pertaining to her work, my lord, had gone missing. Milord, in the 125 maintenance proceedings, when she appears before the court, and Milord, the order for statement of assets and liabilities was passed by the learned trial court. Milord, she was astonished to see that certain documents, which are confidential documents of my client, Milord, has come before the learned trial court, which should not have gone to the custody of the husband, and the husband files it, Milord. Milord, after careful
which proceeding?
in 125 proceedings, Milord, maintenance proceedings. Milord, after careful scrutiny, Milord, she found that when she was not there in the house, her documents, Milord, have been taken away. They have been, Milord, manipulated, and those manipulated documents have been filed in the court. Milord, aggrieved by that, Milord, this private complaint has been filed. She has given the background in the first part, and then she has alleged, Milord, what has actually happened.
What is the allegation in the
Milord,
last
you'll
part?
find.
If you see the seventh line,
My lord,
seventh line from top of the complaint, it says of a date 14th April 2019.
yes,
14th April 2019 already
yes,
the other complaints were filed.
yes.
Now, if the allegations of torture of 1419 is already in the other complaint,
Yes.
so what prompted her to file a subsequent complaint?
No, Milord, she is not giving the complaint, Milord, of 2019. She is only giving the background that she has filed a case. She has stated that I have filed a first case in Milord, just after that, 1, 2, 3, 4, fifth line from the line your lordship has pointed out. এবং 26/11/2020 তারিখে তার স্বামীর বিরুদ্ধে রাজগঞ্জ থানায় একটি লিখিত অভিযোগ করে। So she just narrates the background, Milord, where from the entire thing comes. And Milord, the last line of that page, Lordship will find, এই অত্যাচারের কাহিনী 24/4/2022 তারিখে অভিযোগকারিনী বানারহাট থানায় লিখিতভাবে জানায়। So that is again narration of the fact, Milord, of the earlier proceedings. Next, Milord, বিবরণে প্রকাশ থাকে যে অভিযোগকারিনী তার শ্বশুর বাড়িতে স্বামীর সঙ্গে থাকাকালীন অভিযোগকারিনীর যাবতীয় গুরুত্বপূর্ণ নথিপত্র, ব্যাংক পাসবই সবকিছু তার শ্বশুর, শাশুড়ি, ননদ এবং রঞ্জিত এদের সকলের সলা পরামর্শে স্বামী সঞ্জয় চৌধুরীর নিজ হেফাজতে রাখত, এবং তখন থেকেই সমস্ত নথিপত্রের ছবি তার মোবাইল ফোনে গোপনে চুরি করে তুলে রেখে অভিযোগকারিনীর সাথে প্রতারণা করে। এছাড়াও গোপনে অভিযোগকারিনীর কিছু আপত্তিকর ভিডিও ছবি করে। কোনো মনোমালিন্য হলেই তখন তারা এই সমস্ত ছবি তোলা আছে বলে অভিযোগকারিনীকে ব্ল্যাকমেল করত, যে তাদের কথা মতো না চললেই বা কোথাও কোনো নালিশ জানালেই তারা এই সমস্ত ছবি সোশ্যাল মিডিয়াতে দিয়ে অভিযোগকারিনীকে সকলের চোখে কলুষিত করবে। বিবরণে প্রকাশ থাকে যে অভিযোগকারিনী তার স্বামী কোনো ভরণ পোষণ না দেওয়ার বাধ্য হয়ে তার নিজের জন্য এক নাবালিকা কন্যার জন্য ভরণ পোষণ চেয়ে জলপাইগুড়ি আদালতে একটি মোকদ্দমা করে, যার রেফারেন্স মিস কেস নাম্বার সোয়ানসো। এই মোকদ্দমার অভিযোগকারিনীর স্বামী সঞ্জয় চৌধুরী তার মোবাইল আগেই শ্বশুর, শাশুড়ি, ননদ এবং রঞ্জিত এদের সকলের সলা পরামর্শে পরিকল্পনা মাফিক সংগ্রহ করে রাখা নথিপত্রের কিছু কপি প্রিন্ট জমা করে, এবং বিন্নাগুড়ি শাখার স্টেট ব্যাংকের সাথে যোগ সাজসে অভিযোগকারিনীর ব্যক্তিগত সেভিংস অ্যাকাউন্ট নাম্বার সোয়ানসো এর একটি অ্যাকাউন্ট স্টেটমেন্ট ফ্রম 1 এপ্রিল 2021 টু 31 মার্চ 2022 আদালতে 15/6/2023 তারিখে দাখিল করে। ব্যাংক সঞ্জয় চৌধুরীকে আমার কনসেন্ট ছাড়া অ্যাকাউন্ট স্টেটমেন্ট দিয়ে তাদের নিয়ম লঙ্ঘন করেছেন। অভিযোগকারিনীকে উক্ত ব্যক্তিগণ প্রতারিত করেছেন। অভিযোগকারিনীর বিচারের আশায় তিনি অদ্য হুজুর আদালতে শরণাপন্ন হয়েছেন। So this is, Milord, the crux of the complaint. The material part of the complaint is paragraph 2 and 3. The first paragraph is, Milord, simply the narration of the background facts and nothing else. Now, Milord, after filing this complaint, Milord, I have seen, Milord, the learned magistrate was pleased to issue process under section 379, under section 420, under section 498A as well. Now, Milord, the only thing I understand is, Milord, they are aggrieved by initiation of the proceedings under 498A. Milord, I never wanted 498A. The magistrate in his wisdom has, Milord, inserted 498A in the summons. And in the order sheet, Milord, they have issued process. So, Milord, they have ample avenue before the learned trial court to go and agitate that, Milord. I am giving undertaking before this court that if 498 charges are not framed under 498, Milord, I will not raise any objection. I am giving that undertaking before your lordship on the instructions of my client. But, Milord, the other sections, Milord, 379, Milord, 406, 420, Milord, these are relevant sections in which, Milord, they have to adduce evidence that they have not committed this offense. Milord, this is not a case of coercing, Milord. When the prima facie material has been put before your lordship, my lord. So 498 is a different thing, my lord. I also agree with them. 498 should not come. Under 498, my lord, wrong section has been inserted. During the framing of charges, my lord, that will go. And I will not object.
Short reply to what my learned friend has said, madam. First and foremost, in respect of paragraph 2, which my learned friend has drawn your lordship's kind attention regarding this document part and the some objectionable pictures, madam. These have come up from the first line. Now, for a moment, if I keep apart the document part, the objectionable picture, my lord, no date has been mentioned. When were those pictures taken? Whether they were taken before or after the earlier complaints were filed? A vague complaint, my lord, allegation. Second, with regard to document, my lord, if I have, my lord, taken a document, used it for my benefit before the learned court below, who is in session of that application under section 125, why has that point not been taken up there? My lord, is a question which I put to myself. Why is it required to be brought to the attention of the authorities by way of a separate complaint case, my lord? Is another question which I am putting it to myself. The de facto complainant before your lordship has today made no submission to the effect that there is a legal bar or something has stopped her from bringing it to the notice of the learned magistrate who is in session of that case. First and foremost, my lord. The accounts, my lord. From when are these accounts being used by me? That, my lord, has not been mentioned. Why has that? Because the date will not be mentioned, my lord. I am telling your lordship why. Because the moment the dates are mentioned, my lord, then the question will come that how did you get that date? And if the dates, my lord, is seen to be preceding 2020, then why these were not mentioned in the earlier two complaints? My lord will kindly appreciate the vagueness and the deliberate, my lord, non-mentioning of dates. So these are my points, my lord. I am praying for quashing of the complaint case. Thank you.
Steve.
Holding the case which pertains to Banarat lordship.
2022.
I don't
This
have
is a
the-
private complaint, my lord, so
Those will not be required.
I'm agreeing with the fact that 498A lordship can be seen. Lordship 498 allegations are already there in the FIR containing second one, Banarat lordship. Regarding the allegations, other allegations, they can prove at the time of lordship charge.
At the time after
Framing of charge, during the framing of charge, lordship.
after every completion of before charge evidence,
Yes, lordship.
yes,
they will get opportunity to
yes,
Yes, yes, lordship.
have the sections changed.
yes.
That will get.
Lordship, sir.
Before charge evidence, after the completion of before charge evidence, there will be charge hearing. In which of the proceedings the evidence will continue in after charge.
I am at the vagueness and frivolousness of this entire proceeding.
Only non-mentioning of the date will not make the complaint overall altogether non-acceptable in the eye of. There are dates.
Those dates, my lord, if your lordship is referring to the dates, my lord, those dates have not been emphasized by the de facto complainant in their submissions, my lord. What has been submitted, my lord, those days have been mentioned to give a background. Now, if the dates have been, and why, my lord, I am telling your lordship, my lord, these dates have not been emphasized before your lordship, because the moment this would have been emphasized, in my reply, my lord, I would have shown the contradiction with regard to the dates. Because the date which is mentioned as 22nd of April 2022, in the second FIR, she says that I could not find my husband at home. I go to a local bar and I see my husband drinking. Here, there is a separate thing, it is written, my lord. So that is the reason the dates have not been emphasized before your lordship.
Lord, these are disputed questions of facts, my lord, only can be ascertained by the learned
Yes,
trial
and the
court, my
same
lord.
person, my lord, disputes it every year. Changes it every year. The same incident date. Once, my lord, she finds her husband somewhere else, and the another time the husband drives her out of her matrimonial home on that date.
My lord, that is beyond the records, my lord, what my friend is submitting.
All the written complaints are before your lordship.
When was the 125 proceedings filed?
Initiated in
After this or
2019.
before?
No, 2019, my lord, that is the first. That is why, my lord, I started with my
ঠিক
submission
আছে।
by giving the number of proceedings. First, 125, second is the 2020 complaint, third is the 2022 complaint, then, my lord, the case under Domestic Violence Act, and then, my lord, is the impugned complaint case. So since
The
2019.
evidence in 125 has started.
Yes, it is fixed for argument, my lord. I've given the entire set of orders, my lord, which starts at page 14, annexure P2.
Can you produce the examination of this witness, I mean the complainant in essay,
I have to bring it, my lord.
and the order passed in that proceedings while issuing process?
I have to. I don't have right now with me.
Calcutta, produce it tomorrow?
Day after tomorrow, my lord.
Day after tomorrow, the 30th.
My lord will keep it. My lord has heard it completely.
That's why I'm asking you, produce it tomorrow. We'll pass order.
With respect to which proceedings? Sorry?
Last proceedings. What
What?
was the examination of the witness? What did she state in solemn affirmation? You produce that? And the order passed by the
CR
magistrate. The case you have
The
sought for-
impugned case, my lord.
Yes.
Yes. That, my lord, my learned friend can also bring, but it's his client's case. It is
Mr.
their
Chaudhary,
case,
yes,
my
yes,
lord.
yes.
It will be easier for them. They can get the copy, my lord, it's in Jalpaiguri only. It's their case. It will be very easy for them, my lord. I will make an effort, my
Tomorrow?
lord.
Tomorrow?
Tomorrow, my lord. Tomorrow, my learned friend will produce it. I'll also make an effort.
Tomorrow তো এটা কাগজ উপরের দিকে রাখবে এটা অর্ডার করে দিন
হ্যাঁ পারবে এত ভালো
মিস্টার
Madam,
and advocate for the petitioner.
কালকে পারবে may I, my lord, make one humble with consent of my learned friend, my lord, subject to what a lordship feels. What I could not have done, but I overheard what they were discussing. If they apply for the certified copies tomorrow, today, my lord, by tomorrow, late in the afternoon or evening, my lord, they will get the certified copy. So that is why I made a humble prayer. If your lordship can kindly keep it day after tomorrow,
No.
my lord.
With the consent of the parties, release this matter on 30th January.
Great.
As a fixed matter.
Or yes, yes. If
এটাকে টপে রাখুন
great.
30th টপে
I'm grateful to your lordship.
Mr. Chaudhary, solemn affirmation and the order passed
Not
after examination of the
Grateful, man.
Mr. Mujumdar.
Accommodation for 15 minutes in second half. My learned friend is there, Lord, I shall complete my submission and go. Tomorrow he can produce the case hearing and address you.
14 কে আছে wait
14 minutes.
But I'm 40.
But she told me she will take enough to it. She was there with. I should place my case here.
now
Now.
15 minutes another dot 2 তে 2 p.m. We are planning to have it 2 p.m. Who is for the state? 14 not today.
15.
He wants to make his submission 15, 16.
The lordship can have your lunch and come back at 2 p.m. 15 minutes I shall take, 15 to 20 minutes.
15, 16 and 17.
Yes, about the same matter, same kind of issue is there.
Only whether the service has been affected on the other
Yes,
parties.
because he is the only person.
State.
There's a suo moto case.
State.
Yes.
It is with you.
And he is appearing.
তাই সিভিলের অ্যাডমিশনের আগে তিনটে একটু একটা দিলেই হবে তিনটে হয়ে যাবে ঠিক আছে এইটা শুনে নিয়ে সিভিল সেকেন্ড হাফে দুটোর সময় 15, 16, 17
Deeply appraised.
14 not today.
No, my lord, cannot.
Cannot be.
The petitioner have already taken this interim order, my lord, stay order, and they are
They are just dragging it, my lord. Not to the first, my lord, because they give the copy of the application. After pursuing and listing this matter, they hand over the copy on that day.
Mr. Rajdi Mojumdar submitted that you will be praying for a not today and placing it tomorrow.
This for the opposite party, the petitioner told me that we just.
Oh.
They have already completed all the. What you are saying is that they will place it before the next.
Well, you have the copy has been given.
Yes, madam. Nothing is there, madam. It will take only 5 minutes. But she was getting.
কি অর্ডার করেছিল দেখি তো
আরে নতুন না ওরা তারা কি
এরকম করলে তো অসুবিধা হবে What is this?
Every parties are confirmed through PS. Compliance of the.
কালকে নেবে এটাকে কালকে রাখুন পরে দেখি কি আছে দেখি রেকর্ডটা দেখে দেখি রেকর্ডটা দিন আমি এটা দেখুন তো কোনটা এফিডেভিট অফ সার্ভিস একটা ফাইল করে আগেরটা মনে হচ্ছে 307 এ
And they are also compromises fully, if it is advocate.
He is for the petition.
So we have to become a little matter. This petitioner is one of the accused persons, my lord. In earlier occasion, my lord, 2 accused persons came before the lordship and their petition was dismissed, my lord. And this accused person is principal accused man. The other 2.
What is? You are the complainant. You are the complainant.
Yes, my lord, I am the complainant. Actually, I will find.
Oh, this relates to a death in the apartment. The children used to. There was a. There was a dispute between the parents of the child, and that particular aspect was put in the WhatsApp.
You see the order, my lord, has passed in those. Perceives 161 and the charge sheet has been filed. So without evidence, how will we?
Now, what is the status of this petition? Same.
And my lord, seen this petitioner is the principal accused in this matter. So without the perceives evidence, how will we conclusions? And the charge sheet has been filed and their involvement is there in the CD lordship. It's not a weakness for question at this stage of lordship, charge sheet already filed.
Tomorrow topic দিয়ে দিন এটা লিস্ট করুন তো কালকে topic. You have the CD tomorrow. Some of the statements have also been annexed to the application. কালকে টপে এটা কন্টেস্টেড অ্যাপ্লিকেশন টপে দিয়ে দিন ঠিক আছে আজকে হবে না tomorrow you place the order tomorrow this will appear in the top in the contested application
it is GST portal, page 33 of my application. Your lordship will find. First, kindly turn to page 23 first, GST registration certificate. Page 23, annexure P1. Got it? Kindly see the registration number, kindly mark this number once. It's very, very important. The last 4 digits are D1Z6. Got it?
D1Z6.
Yes. Now your lordship will find legal name Abhishek Kumar Kashyap. He is the petitioner before your lordship. The address of the principal place of business, your lordship will get that it is in Guwahati. Got it?
Yes.
Vijo Islampur, Guwahati. Now, date of liability and period of validity, it is valid from 11th of April 2020. This is as per the GST portal. This is a government of India document.
So in GST, once it is made valid, it will be.
It will continue.
There
It
is
will
no.
continue until and unless it has been terminated by the GST authority. So it's
So there
valid.
is no question of a renewal of the GST.
Nothing. And even your lordship put number in the your lordship's GST portal, and your lordship will get the name from there only. We have downloaded this. This is coming up. Now, kindly see that which your lordship has pertinently questioned. What is the nature of business? Your lordship will get that in page 33. This we have downloaded from the portal itself. But today, all your lordship also can download it from the portal. Your lordship will find the GST number is same. D1Z4. Got it? Now see, effective date of registration, the same date, which is coming out from the GST registration. And what is the nature of business? Your lordship will get it in page 35. 35.
Nuts.
Nuts. Other nuts, fresh or dried, whatever or not, say shelled or filled. So they were authorized to do business which pertains to nuts.
Okay.
This is from the downloaded copy of the GST portal. Now your lordship will find. Now kindly turn to the FIR. Now before that, before coming to the FIR, 2 documents I want to show. This entire consignment kindly turn to the tax invoice, which will appear in page 40. These are also statutory documents in terms of the GST Act.
42.
42. Your lordship will find the first. This is KK Enterprise, consignor, and consignee is Riddhi Enterprise, which is situated at Delhi. Left hand side in box. Page 42.
Who is the complainant? The state is the complainant?
No, state the
Police,
sub inspector of police, so motor complaint by him. First, I shall place the documentation, I shall take the FIR. But how contact the FIR is, your lordship will come to know. Now, your lordship will find consignee, this is, which is the shipment was going to Delhi to Riddhi Enterprise. Got it? The destination Delhi, the right hand side, dispatch through AM Logistic, destination Delhi. Got it? And your lordship will find the GST registration there also. Just my name, just below my name, D1Z6. Left hand side top. My enterprise name, then your lordship will find. And your lordship will also find the GSTN number of the consignee also, H2Z6. This is the consignee registration. Now, kindly see the date is very important. When it was sent from Guwahati to Delhi, that is on 3rd of October 2024. This is a statutory invoice in terms of the GST Act. Tax invoice come charge. Now your lordship will find the truck number, the motor vehicle number, kindly marked it once. Right hand side, the motor vehicle number. Got it? Kindly mark the motor vehicle number also, because it is pertinent when I will mention the FIR. Now your lordship will find the description of goods dried erica nut. Commonly we known as supari. Erika. And your lordship will find the invoices with the GST statutory, the required total amount, your lordship will get it down. So the consignee send the material from Guwahati after obtaining all statutory formality. It was going to Delhi, and your lordship knows better than me, when there is an interstate transport, there the tax invoice come challan, and the next page your lordship EOA bill, which is very, very important. 43 EOA challan, EOA bill. Now your lordship will find EOA bill generated by, your lordship will get D1Z4. This is my GST number, got it, left hand side. Now see, generate date 3rd of October 24, and it was valid up to 12th of October 2020. Got it. Now kindly see, it was going from KK Enterprise, Assam to Delhi. Both the GST number has been given. And interstate transport, the EOA bill is very much required. It is in terms of the GST Act. All are statutory obligations. It has to be covered. Now, kindly turn to FIR now, the malicious and concocted piece of the FIR, your lordship will get that in page 26. So material was sent on 3rd of October, which was till 24th of October. Now,
12th of October.
12th of October. Sorry, now, kindly see the FIR. Your lordship will get the FIR in page 26.
It's formal.
This is formal part. The sections are the stolen property. Receiver of stolen property. Earlier the sections are, your lordship can corroborate it. It was earlier 379, 317 2, which is the stolen property. 414 concealment of stolen property. 468 is forgery, and 471 is the forged document. These are the charges. Now, kindly turn to the written complaint, page 27, which is very, very important.
You give the corresponding sections once again.
Yes, but I'm just here. But for
318 clause 4.
318 clause 4.
4 is
420. 420 दादा.
Hailstone.
318 clause 4, your lordship will get this one.
was for 318. 4. Cheating and dishonestly inducing delivery of property.
Yes. Now, 336 subclause 3 is forgery. Forgery for the purpose of cheating.
Not cheating, harming the reputation.
Yes, harming the reputation.
No,
Then
it is 3. Your is 336 3. Forgery for purpose of cheating.
Yes.
3.
Yes.
Next is 342.
340 subclause 2.
Using a genuine
Document as a forged document.
Yes.
468.
Yes.
340.
And 35 is the conspiracy. Your lordship knows better than me. These are the sections.
Conspiracy.
So, your lordship, the forgery for the purpose of cheating, and the forgery of the documents. These are the 3 sections. Now, kindly turn to the FIR. Page 27. Now, kindly see, I produced herein one accused person, namely Hariom so-and-so, Naval Kumar so-and-so, do arrest memo and following seized articles with original scissor list. 1, it is very important. Kindly see, 1 ta displaying registration number H438A6E6010. In my EOA bill, kindly this truck, your lordship, compare with my EOA bill in page 42.
Same.
Page
42. Right hand side.
601.
same number. Now see, one EUA bill in respect of dried Erica nut of 29,400 kgs, white tax invoice number KK so and so, dated 3rd October 2024. So, my lord, EUA bill they also
Admit.
admit. But this is a statutory document. In terms of the GST Act, this is a statutory document. Now, one invoice come challan in respect of dried Erica nut, which your lordship I just referred in page 43.
Right.
Yes, the same. Consigning your lordship will find GST number is also there.
Hmm.
GSTN number, your lordship will find that my GST number 8DZ4 and other one is H21G. The consigning
Z6 or 4.
Yes, but both are mentioned there.
Of the consignor and consignee.
Consignor.
Okay.
Yes. Now, we will kindly see. One road challan is also produced by the truck. I so and so hereby lodged and written complaint to the effect that on 6/10/2024, the consignment left on 3rd and it was valid till 12th. That kindly mention the date. At about 4:05 hours, received a specific information from source that some miscreants are carrying huge quantity of betel nut by using truck having displaying registration number so and so, but there is a truck number without valid document, but kindly marked it, or procuring fake document for the wrongful gain from Kujbihar side towards Bihar, and the vehicle will be passed through Khairabadi road shortly. I reduced information in writing by PS customer so and GDNT number so and so, and after informing my superior, my work out the information, diarized the matter into GDNT number so and so. Around 5:15 hours, the force reached on spot on the source and required more time to pass the vehicle. Then myself with the force were waiting in the place. At around 20:15 hours, my source informed the said vehicle is going from Bhojpur mode with high speed. Then, as per the information, I managed to stop the vehicle and display the registration number so and so, the truck number, near Bhojpur office, and asked the identity of the driver or helper to discuss their identity at Horion and Naval Kumar. On asking, they stated vehicle loaded with betel nut, which was loaded in Assam. Then I checked the vehicle, displaying the registration number so and so, found the vehicle loaded with betel nut. Then I asked them, providing supported document, they also provide one EOA bill challan of dried Erica nut so and so, and tax invoice of so and so, and one tax invoice of challan of telegram 40 number so and so. And so and so, consignee was so and so, stated that consignor and consignee. Then I cross-checked the GST number of KK Enterprise being so and so through online GST portal and found KK Enterprise is dealing with goods and services and clothing articles. But can you stop here for a moment? Even today, if your lordship put my GST number in the portal of GST, which we have downloaded from the server, it is still showing that we can deal with, your lordship has gone through the document. The nuts, any kind of nuts we can deal with. That is, your lordship will get page 23. Page 33. 33.
So, how is stated that you are dealing with?
That is the reason. Enter malafide. Your lordship knows why the police done it. But I don't want to express my opinion in open court. But your lordship has better experience than us. Why this kind of the activities is going on? And today also, if you are not, they will reply. Let me finish, then we will kindly see the allegation. Then there are reasonable grounds to be submitting documents, maybe false. But kindly mark it also. Even today on online portal, your lordship will get those documents. On information, driver so and so, Uttar Pradesh so and so, helper both made a contradictory statement. After prolonged information, they admitted that some persons are running the business with a wrongful gain. By this such, I contacted the person who directed to seize the vehicle and a legal procedure against persons with the racket. Then myself forced taken the vehicle nearest the weight bridge and so and so. Then I seized the truck bearing number so and so, loaded within a nut with the proper finger so and so, so and so, so and so, so and so. But this is totally not contradictory to the Article 19(1), which says not to carry on lawful business, it's a constitutional right. And your lordship has gone through the all statutory document, which shows that I have the valid permit, I have given the statutory payments, and then only I was not carrying on my business. But this is totally contradictory to the Article 19. On that ground itself, this effort should be quashed. Now, one judgment I shall cite before your lordship. Now, they might point out this is the investigation stage. In a 482, whether your lordship can go through this document, the statutory document or not. But this is very clear from the judgment of the Supreme Court, which is in 1990. No, no, no. Rajesh, sir. But para 29 and 30.
What is the citation?
Yes, blood 2013, volume 3, SCC 330. Whether or not a 482 court can rely on the document annexed with the petition, which is the material of starting point. But that the Supreme Court has decided. But kindly see page para 29. Oh, judgment is this is a compilation. This is the judgment. Para 29. The issue is being examined in an instant case of jurisdiction of the High Court under 482. If it is chooses to quash the intention of the prosecution against an accused at the stage of issuing process, the stage of committal, even the stage of framing of charge. So all these issues are here. These are the stages before the commencement of the trial. Actual same parameters. We will naturally avail the larger stages as well. The power vested the High Court under section 482 at the stages referred to herein above. We have far-reaching consequence inasmuch as they negate the prosecution's content case without allowing prosecution content in the lead evidence. Such determination must always be rendered in caution, care, and circumspection. To invoke inherent jurisdiction of 482 High Court has to be fully satisfied the material produced by the accused in such a would lead to the conclusion of his their defense on based of sound, reasonable, and indubitable facts. The material produced in as such would rule out and displace the assertion contained in the charge level and the accused. And the material produced in such a clearly reject or overvalue the veracity of the allegation contained in the accusation leveled by the prosecution complaint. It would be sufficient to rule out, reject, and discuss the accusation leveled by the prosecution complaint without necessarily recording any evidence. For this material relied on the defense has to be repeatedly cannot be justifiable, refuted, and better material standing and impeachable covered. The material relied upon the accused should be as would persuade a reasonable person to dismiss and condemn the actual basis of accusation as false. But this is we are here. In such a situation, the judicial conscience of the High Court will persuade to exist its power under section 482 to quash a criminal proceeding for that would be prevent the abuse of process of court and to secure the ends of justice. 30. Based on the factors canvassed and following paragraph, we will indicate the following steps to determine, but this is more important, this paragraph. The veracity of a prayer for quashment raised by an accused by invoking the power vested under court under section 482. Step 1. Whether the material relied upon the accused is sound, reasonable, or indubitable, that is the material of standing or impeachable probability or not. 2. Whether the material relied by the accused would rule out the assertion contained in the charge leveled against the accused that the material is sufficient to reject and overvalue the facts assertion contained in the complaint and the material in such a persuade a reasonable person to dismiss the condemn the factual basis of accusation as a false. 3. There are material relied on by accused which has been refuted by the prosecution complaint and the material in such cannot be justifiably refuted by the prosecution complaint. 4. Whether the proceeding of trial will result in an abuse of process of court and would serve the end of justice. If the answer of the steps are affirmative, the judicial conscience of the High Court should pursue its course a criminal proceeding and exercise of power vested under section 482. Such exercise of power besides doing justice the accused would serve the precious time of the court, which would otherwise was the holding of such trial and specifically here there is a conclude the conviction of the accused. Now, Lord, this is the settled proposition. When your lordship is not better than me, when your lordship is dealing in a political application, to secure the ends of justice, the Supreme Court says the material of starting quality, which the prosecution cannot also be, that can be relied on at this stage. And Milord, I am praying for quashing on the basis of the Bhajan Lal's principle number 5 and 7. 102, 5 and 7. But these are the principle in the FIR stage. Your lordship has the power under section 482 or 226 can quash the procedure. But these are the parameters which has been carved out by the Supreme Court, where your lordship has enough power under Article 226 or 482 to quash the proceeding. But I am here relying on 5 and 7. 5, where the allegation made in the FIR or complaint are so absurd and inherently improbable, on basis of which no prudent persons can ever reach just conclusion that there is a sufficient ground for proceeding against the accused persons. Now I'm not reading the FIR, but along with the documents which were annexed with the petition, but which are the statutory requirement under the GST laws, which will not authorize me to carry on lawful business in terms of Article 19, subclause 1. But whether this clause, the complaint is so absurd as improbable, this clause is squarely applicable so far as my case is concerned. But this is not also get it aggravated with clause 7, where the criminal proceeding is manifestly attended with malafide and where the proceeding is maliciously instituted with an ulterior motive for which the accused a view to spite or due to private and personal right. But so we are also on the ground of malafide, but I don't want to express my opinion in open court. My lord is much more experienced than us. This kind of the allegation or acquisition, why it happens, your lordship is much more experienced. But here, my entire property, my lord, the betel nut has been seized by the police, which has been produced before the magistrate. Now, magistrate also rejected the prayer on the ground that the documents are not verified by the police as well. And Supreme Court is saying, my lord, on that issue, I have that judgment also. My lord, within 15 days or 1 month, the material which are perishable in nature, the lordship knows betel nut, if it is kept for long, it will not be rotten. So, Supreme Court says in the old section 451, new section 505 of BNSS, has the power of the learned magistrate to release the material. From these two aspects, I am praying for quashing. Let my learned friend reply my question and answer to the document which I have annexed. The lordship has seen that it's a lawful business which we are carrying on. But if anything required, I shall make my submission.
My lord, first of all, my lord, investigation is going on, my lord. And my lord, and without verifying those documents, till completion of the investigation, without verifying those documents, how can it can be said that the all the documents are genuine or not, without verifying, my lord. First of all, my lord, this is the memo of evidence. Kindly see, my lord. Page 1, 2, 3, 4. Not page 5. Point number 8. Page sorry, my lord. 1, 2, 3, 4. Page 4. Point number 8. Not got it.
Point number 8, yes.
My lord. My lord, got it. Last line, my lord. But no such landmark found in the said address. This is about the, my lord, the address written in the GST document of the court. No, GST. Then my column number 10. 8, 10, 11, and 12, madam. Kindly see.
Ten, 11.
8, 10, 11, 12.
Yes.
Malad, next page, Malad. Point number 16.
Yes.
Then Malad 18. As because the investigation is still in progress, I'm not reading the entire thing, Malad. Thanks. Then 19 and 22. Points number 19 and 22.
Yes.
Malad 22 got it, Malad? Already suspended? Annexure 5, Malad. Check.
What is the page number of E-bill? E-bill, E-bill.
E-bill.
E-bill,
E-bill, Malad 43.
43. Now, they are saying these are forged documents. Whether not they have taken any not the statement from the GST authority, these are forged or not, but that here what she has to see. Whether any statement relating to the GST authority is there or not. And today when Milord, if your lordship make this Milord a GST number in portal, the same bill will come out.
Not at this stage, investigation in going
No, it's
progress,
not going.
Malad.
The investigation has been stayed by the High Court. It was stayed on the 17th of December. And you have started the case, Milord, kindly see when they have started the case. They started
610.
610. So more than Milord 1 month, 10 days they are carrying on the investigation. First thing they were supposed to do, Milord, to take the statement of the GST authorities and whether the bills are genuine or not. Whether they have done so or not. Milord, this is the first point. Other are immaterial. You take someone else's statement, you take a co-accused statement, these are not suffice. The case. Today, my lord, kindly consider whether in terms of the GST Act, I have the valid document for business or not of that, for interstate transport. And whether, the GST permits me to, first allegation, what they have given the allegation in the FIR. That, these are the garments. I only, the GST number has been only meant for the garment business. Is it so? So your lordship will rely on this, that is the reason that I said it's a malicious prosecution by the police. Every fact is concocted.
But then Riddhi Enterprises is showing it is suspended.
Which has been suspended?
Really.
No, Milord, it has not been suspended, it's still valid. Milord, kindly see it. Kindly see the GST number.
Of the consignee.
Yes, consignee.
H2Z6, Z.
Yes.
Status suspended.
Status is suspended.
Which status they are showing, Milord?
We are collecting from the documents. Kindly see.
When it was suspended? Then, Milord, so far as this document is concerned, Milord, I shall take a copy from him. I shall take proper instruction. I shall come day after tomorrow on virtual.
Please do it.
Yes. Otherwise, your lordship got the crux of the matter. If I can satisfy that this.
No, I have understood that
Yes.
since there is a document from the GST authority.
Yes, Milord.
Which you say is a sterling document
Yes.
of transaction we having a bona fide business. He says that the consignee GST has been suspended.
Yes.
So there cannot occasion to rely on GST as per him, as per the e-bill,
Yes.
because
That
the
is my
consignee do not have the have a suspended GST number.
Suspended GST, Milord, I shall take instruction.
You
to that
take
effect.
instruction. Otherwise, if it is a document,
Clarify me what is.
I am not into that whether the business is a clothing business or not. What
Yes.
you have shown that if it is generated through the GST
Yes, Milord.
and it is a valid document,
Valid document.
sterling documents, then
The court has enough power under
Then I
Article
have
26 or 42 to quash the
you
process.
take this
Yes.
back.
Yes.
Just give me one copy, Milord. Kindly ask my learned friend to provide one copy of
I'll provide.
But Mr.
Hey,
Rajdeep
hey.
Majumdar,
No.
learned senior advocate, appearing on behalf of the petitioner. He submits that the petitioner has dealt with dried areca nut.
So, Milord, your lordship, just now I have checked it. On 13/11, this is showing suspended. Whether at that point of
That
time.
you take in.
Yes.
I have seen the
Yes,
date.
yes.
I have seen the date.
And Vidhi, Milord, I have annexed.
Sir, you also take instruction because
Yes.
this has been given from the CGST.
Yes.
Carol Bagh, Delhi.
Yes.
You also see that whether at the time when the cause of action arises.
That
whether it
time
is valid.
that was valid or not?
But kindly
Valid or
mention
not,
it in
because-
lordship's order, reflected in
See.
your lordship's order.
Huh?
Kindly reflect it in your lordship's order,
Yes.
so that both of us, we can, Milord, try together.
Okay. এগুলো has their petitioner has made consignment to Vriddhi Enterprises of dried areca nut on the basis of a valid document
Sorry for interruption, but kindly see page 33 of my petition. This is Vidhi's effective date of registration 11/4. Kindly mention it also, Milord, so that we can take proper instruction. Page 33. Oh, sorry. No, I'm sorry. This is
Effective date of registration.
37.
37.
37.
No, it cannot be. Milord, kindly see date of effective registration 14/8.
14/8/2024.
So it cannot be suspended. I have to take registration, instruction on it.
My lord, last paragraph, GSTIN, UIN status suspended. They are document, my lord. Page 37. They are documents.
Milord, Milord, this.
Last line, my lord, last line of their documents.
37.
Page 37.
Yeah, GST suspended.
But I shall, sir, Milord, we also have not produced it from online at a time of filing. So my lord, I shall take out whether even if it is suspended, whether business can be permitted or not also. I shall take that.
How can it be possible, my lord?
Now we take the other stance.
But let me take instruction on this.
Because see, it's clear. If it is suspended, then there cannot be any consignment to a suspended consignee.
Yes.
I shall take instruction to that.
কি বললো? Concerned on the basis of a valid GST document and e-bill.
একই issue।
However, suo motu complaint has been lodged by the police authority on the pretext that the documents which were produced at the time of search was forged one. Yes, Mr. Mujumdar, this is your submission. At the time of seizure,
Yes.
they have proceeded on the pretext that those are forged documents.
False document.
False documents. Mr. Ajay, on the contrary, learned advocate, Mr. So-and-so learned advocate appearing for the petitioner, state opposite party, submits that during the course of investigation, it has come to fore that the GST number of Vriddhi Enterprises consignee, within bracket consignee, has been suspended. Stop. At this stage, Mr. Mojumdar, learned senior advocate for the petitioner, seeks accommodation to take appropriate instruction from his client. What about the other cases?
Other cases, you
My
not.
lord, same issue involved, my lord.
Same
Kindly-
issue involved.
Same issue involved।
Same issue.
GST
All same.
Kindly heard this
All
first, my
same.
lord, then my lord।
Huh?
বলুন এটাকে আগে শেষ করি, একই ম্যাটার।
But other one of the petition, Vidhi is not the consigned.
Then this argument will not hold.
Yes.
I don't know what is in the memo of evidence of that.
Yes, my lord।
But let it be tagged together all this.
Yes, yes,
All will appear.
yes।
কি বলুন?
Instruction from his client.
Regarding the aforesaid suspension of GST of the consignee, namely Vriddhi Enterprises. State learned public
State advocate।
state advocate is also directed to take appropriate instruction as to whether regarding the date.
Yes.
Date
Date,
is
my lord,
mentioned in the-
6/10, date 6/10/2020।
On the date,
No. Is it mentioned in the CGST? The
No,
date
there
on
is
which-
no, date,
It's not
date is not mentioned, date is not mentioned।
Suppose on the date the transaction is made, it is valid.
Yes,
Then he has a
that
valid.
may be, that may be।
Do this.
maybe this may be because the consignee did not get the goods, although it has been sent and police has detained, that is the reason it also may be suspended. So we need to take instruction on that issue also.
Take
And
instruction.
I
may be,
think
it may
that that is the issue, because GST authority, your lordships know.
Maybe।
Instruction regarding
Yes,
the
that is the issue.
date of suspension.
তাই তো হয়। তুমি একটা মান নিলে তুমি পৌঁছালে না ঠিক মতো।
তাহলে সাসপেন্ড হয়ে গেল।
হ্যাঁ।
তুমি ওদের কাছে তুমি ঠিক আছে, হতে পারে।
If it is prior to the date, then I
Ah.
think you have a.
Yes, yes।
If it is
Then I have,
beyond
then
that
I have
period,
case, then I have
that
case।
period it was valid.
Yes,
Then they don't have any case.
yes।
List this matter on
Day after tomorrow.
Day after tomorrow, I have also collect the
30 থেকে রেখে 30 থেকে টপিক কিছু আছে?
কালকে সকালে কোর্টে উইথ অরিজিনাল সিগনেচার। তিনটা কেস।
টপে তো ওটাই আছে যেটা আগে হচ্ছিল। ওইটার পরে এটা থাকবে, ওইটার পরে এটা সেকেন্ড টপে 3টে দিয়ে দেন। এটা কন্টেস্টেড অ্যাপ্লিকেশন।
কন্টেস্টেড অ্যাপ্লিকেশন।
This has been contested application.
Under the heading contested, there is
Second.
one top matter that
Yes,
was
yes.
arising.
No, deep level. Deep level.
Kindly place these judgments on that day. Wait.
My father will be there, but.
No.
Grateful. Grateful.
Give your best
Thank you, Mr.
for accommodating you.
Thank you, thank you. चलो civil. Civil is up. Fifteen, 15টাই অর্ডার করবেন 16, 17 অটোমেটিক্যালি ওর সাথে লিস্ট করে দেবেন 15, 16 তো এমনি নট টু দেবেন 30 এতে ওটাকে লিস্ট করবেন বুঝেছেন 15টাই অর্ডার হবে 16, 17টা ওর সাথে লিস্ট হয়ে যাবে নট উইথ ইট উইল বি সেপারেটলি অ্যাজ টুডে যেরকম লিস্ট করা আছে সেপারেট থাকবে পরপর লিস্ট করবে
Well, it was posted for filing of the affidavit service. We dispatched it, it has come on as refused, ma'am.
Who has reviewed? You are plaintiff?
Yes, ma'am.
Defendants. That's, defendants are contesting the suit.
Yes, ma'am. Yeah.
Refuse.
Yes, ma'am.
Refuse.
Both
What is the
have been-
case?
Both have been. So we'll hear the matter. Well, this is an revisional application arising out of
What is the suit?
Malak, the suit is for recovery of possession and delivery of cast possession.
Okay.
Malak, the plaintiff preferred an application praying for commission under Order 26 Rule 9. Because the learned trial court was pleased to reject it. Sealing that order, the plaintiff petitioners have come before before your lordship. Now, at the very outset, my lord, there were 2 points of consideration which were raised on the last occasion by this honorable court. The 2 points of consideration was especially, I'm just reading the last order, especially when in the written objection, the defendants have categorically stated that in case of any urgency, if there be any appointment of commissioner, the land of the plaintiff and the defendant be measured by metes and bounds. So, my lord, this appears to come from the written objection of the defendants. That is why what I presume is why the service was refused is because the defendants in their written objection to my commission application had conceded to the fact. I'm just reading the written objection, the relevant.
You read your application. What was the prayer made in your application?
My application was for commission to demarcate area of 0.14 acres in plot number 121. That your lordship will find in page 4 of my application, main application.
Page 4.
Page 4 of my application, revisional application.
Pagination. You have not made pagination?
No, my lord, I'm referring to the main application, revisional application.
Where is your application under Order 26 Rule 9?
It's with the certified copy.
Certified copy.
Yes, sir. It is after my plate.
Plaintiff is not in.
It's in paragraph number 3, madam. The same I have reproduced it for your lordship's convenience on page 4 of my revisionary application.
The following are the ones. 0.1 Yes. What is the written objection?
The written objection, I invite my lord's attention to paragraph number 4. It is also in certified copies, my lord. Paragraph number 4 of the written objection spells out that, however, in case of any urgency, if there be any appointment of commissioner, the land of the plaintiff and the defendant be marked by metes and bounds strictly as per. We have conceded to my application for praying for commission, madam. Now, I'm taking the written statement, my lord. Just few pages ahead of the written objection. On page 2, internal page 2, paragraph number 9 of the written objection. Now, there is the boundary dispute. Paragraph 9, page 2 of the written statement. Yes, ma'am.
Yes.
Paragraph number 9, towards the middle of the paragraph, my lord. The defendant number 2 never did install water tanks as described in Schedule C property. Now I read, my lord. The Schedule B or C property does not belong to the plaintiff, or these portions of the land do not fall within the Schedule A property. Now they are disputing my ownership of Schedule B and C property. I further go on to read, my lord. The defendants do not have the habit of encroaching others' property, nor do they have entered into the premise of the plaintiff. Now, at one point in the same breath, they are saying, I am not the owner of B and C property. Now go further to read. The northern portion of the Schedule A property, which forms the southern portion of the property of the defendant number 1, was barricaded by barbed wires. Now this clearly spells out a boundary dispute. Now I wanted to ascertain the boundary by way of my Order 26 Rule 9 application.
Schedule A is your purchase property.
Yes, my lord. Schedule A is the biggest plot of land. And then B and C are the subplots inside Schedule A property, madam.
Oh. Schedule B and C has been encroached by the defendant. That is your case.
Schedule C, my lord.
Schedule C.
C, which comprises of 2 decimals of land.
Okay.
Now I'm inviting my lord's attention to the impugned order. In the impugned order also, the learned trial court has observed in fifth line, my lord, he further submits that the defendant has conceded to allow the petition. They have conceded to allow the petition, which is most likely they refuse the service of this revisional application also.
Okay.
So now I'm taking the objection raised by the defendant, opposite parties. Learned court for the defendant raises objection and submits that the plaintiff is a non-tribal person, but he purchased property for tribal, so he has no right, title, and interest over such property. He finally prays to reject the petition. Now, this is what I'm trying to impress upon the honorable court is because this order should not have reflected this, because this is a wrong forum.
Wrong.
The civil court, which was hearing the petition, reflected in the order that I do not have right, title, interest because my title has been challenged because I have purchased the property from a non-tribal. This was the lookout of the minority backward classes and the district registrar. I don't know why this defense of the defendants came upon in the impugned order, my lord. Now, this clearly spells out the boundary dispute, and the learned trial court has burdened me with fishing out of evidence and dragging the matter. No, my lord.
Evidence is closed.
No, my lord. We are there on 5th of February. It's posted for framing of issues.
Okay.
Framing of issues. No, Your Honor, this is CO which Your Honor, which this is a CO 165 of 2023. My lord has authored this judgment.
No.
165 of 2023. My lord, I'm directly taking my lord to paragraph number 6 of my lord's judgment. I'm just reading from the middle, my lord. It was vested with the state. It is further contended that the portion of the suit land which was in possession of the plaintiff was trespassed by the defendant number 1 and 9. Now I'm skipping 4 lines and reading. The defendants have been growing tea in the vested land measuring about 6.25 acres. In the case in hand, my lord, they have installed water tanks on Schedule C property and are selling water from there, from the encroached portion of the suit land, my lord. The now I'm skipping a line and reading. On comparative analysis of the pleadings as aforesaid, there cannot be a quarrel over the fact that there is a serious dispute with regard to the area and boundary of the land in question between the parties. The petitioner plaintiff has also pleaded a case of trespass of land by the defendants and recovery of the encroached land. The identity of the suit of property has also been challenged in the written state. My case squarely fits your this CO 165 of 2023, which my lord has authored. And the learned trial court rejected the application of the petitioner plaintiff for local investigation commission on the grounds that such application has been made to fish out evidence. The impugned order also says that I have filed this application under Order 26 Rule 9 to fish out evidence and to protract the hearing. But the lower learned trial court has not considered that it is my suit and I have prayed for repossession of the disputed property. Now I'm inviting my lord's attention to paragraph number 8 of my lord's judgment. The provisions clearly manifest that in any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matters in dispute or of ascertaining the market value of any property or amount of mean profit or damages or annual net profits, the court may issue a commission to make such investigation. In the present case at hand, there is a dispute with regard to trespass encroachment against defendants, as well as area and boundaries of the land in question. Therefore, in order to ascertain the aforesaid aspect, the only recourse is to direct for a local investigation commission. And with this observation, my lord has allowed the application under Order 26 Rule 9. So is my prayer before the Honorable Court to set aside the impugned order and allow my commission application under Order 26 Rule 9.
Okay. This civil revision is filed by the petitioner plaintiff for setting aside order number 6 dated 17th December 2024, passed in title suit number 2 of 2024 by Learned Civil Judge Senior Division Carcium, rejecting the prayer of the petitioner plaintiff for local investigation under Order 26 Rule 9 of the Code of Civil Procedure. Ajay, ऊपर लिखे दिन affidavit of service filed on behalf of the petitioner is taken on record. Next. The brief fact of the case is that the plaintiff, petitioner plaintiff filed a suit for There is no prayer for recovery. Hmm?
Yes, what?
There is no prayer for recovery.
In paragraph 13D of my claim,
Decree for delivery, yes. But that is only with regard to then you are in a scheduled property, right?
yes, ma'am, because
C is a place where there is illegal encroachment and installation of some water tanks. In C.
in C, madam. C is a part of it.
কি বললাম? Suit for declaration, comma, delivery of khas possession of Schedule C property being title suit number 2 of 2024 pending before Learned Civil Judge Senior Division at Karsiam. In the said suit, the petitioner plaintiff filed an application under Order 26 Rule 9 of the Code of Civil Procedure 1908 within bracket hereinafter referred to as the code. Upon hearing both the parties, the learned trial court rejected the prayer for holding local investigation commission. Hence this revision. Mr. Hassan Bhutia. Mr. Hassan Bhutia, learned advocate appearing for plaintiff petitioner, submits that the plaintiff in this suit has sought for declaration that he is the absolute owner in respect of a scheduled property and also sought for a decree granting demarcation of northern boundary of the Schedule A property by way of survey commission. The defendants have installed bamboo fence and water tanks in this C schedule property. The plaintiff has sought for delivery of khas possession of the C schedule property. The prayer for local investigation made by the petitioner plaintiff is innocuous one, since for adjudication of the area of civil property and the encroached portion that is the C schedule property by the defendant. কি বলেছিলাম sentence to adjudicate that. Take stop. Is the only recourse. The learned trial court rejected the application on the ground that the sale deed records the boundary of the A schedule property and that the plaintiff, by way of such application, is trying to fish out evidence. However, it failed to appreciate that for proper adjudication of the issues raised by the plaintiff in his suit, Local Investigation Commission is very much required. He also draws the attention of the court to the fact that the defendants in the suit conceded to the prayer of the plaintiff for holding local investigation commission. He seeks for appropriate order. In support of his contention, he relies on the decision of this court passed in Sri Ananda Chandra Pal versus Santosh Rai and others, CO 165 of 2023. Upon perusal of the order impugned, it is found that the learned trial court has rejected the application on the ground that there is no need to determine the boundary of B schedule property as it is mentioned in the sale deed of the plaintiff, and that the plaintiff is trying to fish out evidence and drag the proceedings of the suit. In order to appreciate the despite it is found from the affidavit of service that the consignment / notice sent to the defendants opposite parties has returned with endorsement refused, postal endorsement refused. Such refusal amounts to good service. এবারে চলে আসুন। In order to appreciate the argument advanced on behalf of the petitioner, plaintiff, it would be profitable to reproduce relevant provisions under Order 26/4, a judgment para 7 এ আছে, না? The provisions as aforesaid clearly manifest that in any suit in which the court deems local investigation to be requisite or proper for the purpose of elucidating any matter in dispute or of ascertaining the market value of any property, or the amount of any mean profits or damages or annual net profits, the court may issue a commission to make such investigation. In the present case at hand, there is dispute with regard to encroachment made by the defendants in Schedule C. Therefore, in order to ascertain the aforesaid aspect, the only recourse is to direct for a local investigation commission. It is informed by the learned advocate for the petitioner plaintiff that it has been fixed for framing of issues.
On the 5th of
The
February.
suit is fixed for framing of issues, and the evidence has not yet commenced. Such being the position, the contention of the learned trial court of fishing out evidence and dragging the proceedings does not hold good. Good. এখানে একটা 11 এ সুলতান আহমেদ মল্লিক আছে প্যারা 11 এ এবং সুপ্রিম কোর্টের জাজমেন্ট The Honorable Supreme Court in Calcutta. This court in Sultan Ahmed Mollik and another versus Mehraj Mollik observed as follows. তিনটে জাজমেন্ট আছে 9, 10, 11 ঠিক আছে 9, 10, 11 সেটাও করবেন bearing in mind the aforesaid proposition, it manifests that where dispute relates to area of land, identity of land, boundaries of the land, encroachment and case of demarcation, it is appropriate to direct for local investigation commission. Para. The appointment of a commissioner for local investigation is indeed to secure para 13, 12, 13. In view of the above discussion, the civil revision being number such and such stands allowed. The impugned order dated order number 6 dated 17th December 2024 passed by learned civil judge senior division Karsiam entitled suit number 2 of 2024, rejecting the prayer of the petitioner under order 26 rule 9 of the code is set aside. The application of the petitioner plaintiff for appointment of a local investigation commission stands allowed. Then a trial court is directed to appoint a local investigation commissioner for holding commission. Baki do same. Dispose of. Chaliye. On no matter.
Extraordinary miraculous
What is it?
We have two applications for expedite hearings are there.
Item number 25.
25 and 26. You kindly take the market aspect.
My lord, item number 23.
Tomorrow
25 and 26. These are for expeditious hearings, but I'm
service complete.
Service not done.
It's admissions.
I am not casting aspersion on anybody. Only thing that my matter is pending for 6 years, my lord, I have made an application under order 14 rule 2. That application be heard out within a limited time frame. That's only fair. I am not.
কালকে একটু দিয়ে দিন না tomorrow.
My lord, item number 23. My lord, it was the matter my lord had heard.
করে দিকে রাখুন ওটা 25 and 26 দিয়ে দাও no other matter. So,
My lord, item number 23. My lord had heard it previously, my lord.
ওটার পরে এটা থাকবে এই দেখে নিন তো 25, 26, 23 কাট করে দেবেন তো এটা সত্যি শোনা হয়েছে সে সিঙ্গানিয়া টুমরো
Great deep pleasure.
হ্যাঁ স্যার
Yes.
কালকে ফিক্স ম্যাচিং না কালকে এমনিও 3-4টা ম্যাচ আছে ফিক্স
কালকে এসছে তো কালকে পাঠিয়ে দিয়েছে